the market fees are just being transferred to be used by the market operator. Yun lang po ang panon. And there is no profit being collected from that asset, Mr. Chairman.
Yeah, but if you look at the financial statement now, starting yung capital 7,000, pag inad mo na ngayon yung assets yan, billion na po yan, naging billion.
They don't get to own that. They don't get to own that asset. They don't get to own that asset, Mr. Chairman.
So sa books, secretary sa books or sa papers, who are the owners of the assets which PEMC bought over the years through the market transaction fees that it billed consumers. Sino pong owner?
The asset is still belongs to PEMC. And then it is just being transferred by function of law, being transferred to the market operator. So wala po yung hindi po yung nagiging asset ng IMAP. Ang asset lang po ng IMAP ngayon, I believe, hindi ko pa rin natingnan yung kung ano listahan ng assets nila po are the equipment that they must have acquired over the 2 years period.
So parehas din nga. So ang nag-benefit pa rin from buying assets from the proceeds of the market transaction fees, PEMC. So magkano naman yung capital ng PEMC? Kasi SEC registered din po yan. Was it also registered as a non-stock, non-profit organization?
It's also registered as a non-stock, non-profit organization.
With how much initial capital?
Yes, I'm having a chat.
So ganun din nga ang ending. Kasi ang ending, pagbasahin mo itong ipira nga na ini-implement nyo, supposed to be secretary, ipapasa talaga yun, shall be transferred. Transferred, papasa mo talaga. Gagawin mo ng owner of the assets of PEMC ang IMAP. As far as I understand this provision, so from a 7,000 capital entity, magiging recipient of multi-million, possibly umabot na kaya ng billion yan assets from PEMC.
Well, I will take that up and discuss and give you the.
Yeah, Mr. Secretary, kasi sabi mo kanina you're just implementing the IPIRA law. May second part po yan. An independent entity shall be formed. Pero merong So yun, marami pa yun. Function, asset, liability. Doon lang ako nakatingin sa asset. So laki na nung asset siguro niyan. Tapos ganito ang question ko.
I have to look at the Mr. Chairman because after all this has been organized by the policy of the DOE as a policy making body, bumitaw na po kami sa mga transfer ng assets po. So I will revisit that and how it is done between them.
Wag po kayong bibitaw kasi you said that you're implementing
I did not interfere. I did not interfere into the transactions.
Because you're implementing the law and that's part of the law. Hindi lang po yung independent entity shall be formed, meron pong meron po doon susunod. Kaya napakagandang topic po itong na-introduce Mr. Chairman Senator Gatchalian. Napakagandang topic itong na-introduce ni Senator Manny Pacquiao. Dito pa lang ubos na yung oras first round. Dito pala sa new topic, hindi pa tayo nakatanong doon sa budget presentation ng DOE. Pero siguro last question sa first round, Mr. Chairman, first round lang para makabigay yung iba, para mabigyan din ka namin ikaw ng chance magtanong, Mr. Chairman. Pero siguro yung sa 702 million, Ma'am Agnes, chairperson, sa pagkaintindi ko, dahan-dahan ko na naintindihan yung table you gave a provisional authority pala. That's why the PEMC collected at that rate. And then ang total collection niya, 702 million. Ganun po ba yun? Ganun po ba yun, ma'am? You gave a provisional authority. That means you made some preliminary calculation and then you authorized them. Pero upon further study, ang sabi ninyo, you made, siguro you applied a different formula and then sabi niyo hanggang 486 lamang dapat. So, what is the best year that anong best year, ma'am, gamitin natin as an example that you said that 486 lamang dapat ang kinolekta?
Actually po, Your Honors, kaya po bumaba from 702 to 486 dahil po nung amin ang sinusuri ang submissions ng PEMC, hiningan po namin ng mga supporting documents. At doon po nagkaroon ng pagkukulang dahil na rin nagpalit-palit na ng empleyado ang PEMC, hindi po nasubmit. They were not able to substantiate the computation of 702. So and the policy in ERC is if you will not be able to one, to substantiate the proposition, then that cannot be considered. Another thing is that if the expenses are not reasonable and relevant, then ERC also will ultimately disapprove that. Now, there were also some items there which actually were savings or unspent, and it was classified as committed expenses. And insofar as ERC is concerned, we do not approve committed expenses, meaning expenses that would have been paid but were not paid, or incurred but were not paid, because insofar as we are concerned, the expenses must be relevant and prudent and substantiated.
Ma'am, anong year yun? Anong year yung, for example, para lang magamit kong magandang example, anong year yung sinabi ninyo na 486 million lang dapat yung inyong budget? Anong year po yun?
Yung po para sa years 2015 to 2017, Your Honors. So wala pa pong IMAP doon.
Oo nga, how come ginagamit pa rin yung ano nyo, yung provisional authority ninyo na based on the calendar year 2014? So dapat yung binabago na yan. Bakit itong table na ito ba? Kaya nakakalito yung table na ito. Dapat itong table na ito, since nagsabi na kayo na 2015 to 2017 ay dapat 486 na lamang, dapat deemed amended na yung approved provisional authority. Is that correct, or am I wrong?
Well, that is the intention of the final authority decision of ERC, which is to correct the 702 under a provisional authority, then now to 486 level under the final authority, Your Honors.
Kaya nga, ma'am, so are you disappointed that sa table na ito, it did not even reflect your 486 million? Kasi provisional ibig sabihin nun, madali ang computation yun. O sige, yan muna. Pero ito, mas malalim na computation, 486. So dapat yun na yung hindi na gumagamit ng provisional authority. But what do we call that authority? Final authority? What do we call it?
Final authority po, Your Honors.
So do we suggest, ma'am, the correction of this table so that after the year 2017, dapat they put an asterisk na doon na may final authority, which is 486 million. Tama po ba yan o mali?
Well, Your Honors, actually PEMC elevated to the Court of Appeals the final decision or final authority of 486 million. In other words, kinwestiyon po ng PEMC yung aming yung authority ng ERC or yung decision ng ERC to bring down the level of the market transaction fees from 702 million to 486 million, Your Honor. That may be the reason why the 486 is not yet being implemented.
Kaya nga, pero and then sila yung they are now free to still collect that amount, so we arrive at our market transaction fee rate. Ganun papabaliktad yan They're targeting the amount, then gano'n. So, dapat, dapat if they are cautious and conservative, their new target amount should be 486M pursuant to the final authority of the ERC. Hence, the market transaction fee should be actually be even lower. Dapat ganun yung conservative approach, hindi yung they are using ERC to bind your hands from changing your provisional authority. Kawawa naman po kayo. Nagagamit kayo ng yung inyong earlier pronouncement is being used against you now to tie your hands so that you cannot change your mind. Ganon po ba yun, Madam Chairperson? Na ang theory nila, you cannot change your mind. Na touch, parang ako, I'm a chess player, parang touch move. Nahawakan mo na yung pyesa during the provisional authority. You can no longer change your mind. Ganon po ba yun?
Well, personally, Your Honors, I view that as a legal relief being availed of by a party that is questioning the final authority of 486 from a level of 702 million market transaction fee, Your Honor.
Sige ma'am, ganito na lang, maybe Mr. Chairman, maybe if we can ask the ERC, since I don't think this is confidential information anyway, what items of expenditure, what other expenses, what purchases were you theoretically allowing the market operator when you first arrived at 702? And then what did you use when you then arrived at 486? Para makita namin if there were changes in the or pwede kasing walang changes except that walang substantiation yung ibang categories or items. Pwedeng ganun ang nangyayari. So tignan na lang po natin, Mr. Chairman, can we request that, Mr. Chairman, from the ERC? Yun, for formula or categories, items of expenditure and expenses they were looking for as far as the PEMC and IMAP are concerned.
Madam Chairperson, just submit to us the request of Senator Pimentel.
So,
Yes, Your Honor.
Mr. Chairman, napakagandang topic nito pero mukhang hindi natin ito matatapos ngayong araw at tsaka medyo na-interest siguro ako dahil ako isang abogado, meron palang legal issue rin ito pero hindi natin ito masusolve sa hearing kasi na-pending sa Supreme Court na pala ito. So, Mr. Chairman, I will suspend my interpellation so that you will have also a chance to ask questions, Mr. Chairman, before kasi lunchtime na rin pala. So, Mr. Chairman, is that okay? I'll just defer to the second round. I will now ask questions on the budget presentation of the DOE.
Oh, no worries, Senator Pimentel. It's always my philosophy to give our senators the priority to ask questions. Total, I interact naman with the ERC and the DOE and the other agencies on a regular manner. No, we talk quite often, so I will defer my time to our senators. But on this point lang, since Senator Manny Pacquiao has opened this topic, I just want to ask the ERC. Ma'am, you said that the final approval is 486 million. Is that correct po?
Yes, sir. Yes, Mr. Chair. Yan po.
They're still collecting 702 million to date.
Yes, Your Honor, because the instruction of the directive of ERC is really to make a refund of the difference between the 702 million under provisional authority and the 486 million under the final authority, Your Honor.
So may utang pa ho ang PEMC and IMAP sa atin as consumers. They're overcollecting what the regulator approved.
That's the one, Your Honor, that is included in our directive, Your Honor. But as I mentioned earlier, Your Honor, the decision of ERC has been elevated to the Court of Appeals, Your Honor.
Okay, okay. Yeah, but well, first of all, thank you very much, Chairperson, for protecting the interests of our consumers. Of course, I will always go with the lower rates, the 486, because that will save us a lot of money. No? And I commend you for standing your ground on that aspect. Let me just go again. No, I just want to pursue this because, like what Senator Pimentel said, this is an interesting topic, and I just want to make it very, very simple, so that everyone will understand. Madam Chairperson, the reason why you are not recognizing ANAP, because in the eyes of ERC, there is only one independent entity. Tama po ba?
Yes, Your Honor. Also, for the reason that the market operation was being or has been handled by PEMC, Your Honor. But of course, Secretary Cruz mentioned about the transition.
Yeah. May I request someone flash that section 30? May I request that section 30 to be flashed? I think it's with DOE. Okay, flash po kanina. Who has that slide? So, Madam Chairperson, in section 30. So, in your interpretation of this provision, there should only be one independent entity, correct?
Your Honor, it's not exactly the interpretation of ERC, but the interpretation or opinion of the DOJ, Your Honor.
Okay.
That there should only be one entity, Your Honor.
Okay. And to date, there are two entities. You have PEMC and you have IMAP coexisting. Is that correct?
Yes, Your Honor.
I want to ask Secretary Cusi, anong trabaho ngayon ng PEMC? Because IMAP is the market operator as prescribed by the law, because all functions, assets, and liabilities of the market operator shall be transferred to such entity. So in other words, everything. Walang matitira po sa PEMC. So what is now PEMC's role? Secretary, can you turn on your mic? Secretary, you're on mute po. You're on mute.
Yes, thank you, Mr. Chairman. The PEMC is the governance body. That's what I would be saying, that they look over the shoulder of IMAP in the market operation, considering they are the market players. And IMAP is the independent market operator. And as I've said earlier, this is a transition because over the years, more than 10 years, PEMC has been there doing everything. So we just plucked out the operation to give that independent market operation to an independent body that would truly protect the interest of the consumers. So sabi ko nga po, transition ito, eventually, sa filing po dapat nito sa filing po dapat ng fees, isa lang po 'yan. Hindi po dapat na dalawa po, isa lang po. So that's what we are doing, and as said the good chairman of PRC mentioned that it is with the Supreme Court. But I just like to reiterate the responsibility of DOE as the policy making body, and we made that IMAP, the independent market operator.
But Secretary, I'm reading this provision and also the IPIRA law. No, I have the IPIRA law here. Nowhere in the IPIRA law says that a governing body or a governance body shall be established. So what is the legal basis of that governance body?
Kasi nga po, Mr. Chairman, because of the failure of DOE in the past to form the independent market operator, nagkaroon na po ng panitong PELSIC. Nandiyan na po. Sila na po ang nag-operate. Sila na lahat. Yun nga po ang naging problema doon. And then there is the provision that it needs to create an independent body. You need the endorsement of both the industry players and the DOE. So hindi na po nagawa-gawa yan. And that's why we did it. We forced our way to do it to create that independent body. Kaya nga po sinasabi ko transition in respect to those nagawa na po dati yon. Hindi naman po pwedeng yung isa na lang natanggalin na lang natin yon. No? There is a transition, picking up what is good and trying to synchronize the work, na hindi magkakaroon ng disruption. Kaya sabi ko, tinanong na
Mr.
sinabi
Chairman,
hindi na yan, na bakit pangunahan. Sinasabi ko lang, nagkakaroon ng transition, and yes, we are looking into it, na kung paano iayusin po yung sitwasyon. Thank you, Mr. Chairman.
Senator Pacquiao, go ahead.
yes, Mr. Chairman, gusto ko lang matanong si Secretary na yung i-explain niya, transition, wala po yan sa IPERA law. Malinaw pa sa sikat ng araw ang IPERA law na wala po yung transition doon sa IPERA law. And then, if we are talking about transition, dapat okay lang yan, isang buwan para 2 months, okay na. Pero 3 taon na ito eh. And then also, paano maging transition na, Mr. Chairman, Mr. Secretary, paano masasabi na transition lang ang ginagawa ninyo? Dahil unang-una, itong si Richard Littlecote, nandyan din sa IMAP. Nandyan sa PIMC siya, tapos nasa IMAP naman siya. Nasa board din siya ng IMAP. So kung presidente siya ng PIMC, tapos president and chairman siya ng PIMC, ng IMAP, magkakaroon na ng conflict yun. Kaya nga kinuha na, according the IPERA law, sabi ng IPERA law, Mr. Chairman, na kailangan kumuha ng independent body with experience, with capacity, and then hanggang ngayon, kaya, Mr. Secretary, gusto ko lang linawin, ang tinitingnan ko rito, paano natin mapababa yung singil ng kuryente. Pero dito sa nakikita ko, lalong tataas yung singil ng kuryente dahil sinasabi mo, yung mga charges na kinukuha ng IMAP at saka ng PIMC doon sa power generator. It's a charge nila yun sa mga consumers. In short, doon nila charge sa mga consumers yung mga tao na nagbabayad. Gusto ko lang linawin lahat, Mr. Chairman. Wala sa IPERA yung plan na yan. Saan kinuha ni Secretary po yung transition na yan, yung ang nagiging labas nito ay Big Brother, dalawang company, parehong mga tao ang nasa kampanya niya. Mr. Secretary, can you give us enlightenment?
Yes, Mr. Chairman, if I may.
Go ahead, Secretary.
Very clear po naman sa IPERA law that one, DOE to create the WESM. Number 2, we have to create the WESM rules. Number 3, to form the transition market operator. To form the transition market operator. And then form the independent market operator. Ano po? I'm trying to say is that over the years, hindi po nga nagawa yung market operator, the independent market operator. And over the years, because of the problems created of not creating the independent market operators, ngayon, para po magkaroon ng isang body, kailangan po ng transition para sa pacing, ano po. Kasi may mga issue even po sa budget, no. Yung sa budget, nag-issue na po kami, the market independent operator is IMAP. Ngayon, ang ERC po, ang iba ang ginagawa na PEMC ang filing ng budget. But the policy is there. Anyway, it's already with the Supreme Court. We respect that and we await the decision. So, ngayon po, tingnan po natin create ng independent market operators. Sa hirap po ng pagpagawa noon po, no? Create na ito pong kailangan ng endorsement by both the players and the DOE. So, tagal-tagal na nga po yan over the years. So, nandito na po yung independent market operators. Who are the people of independent market operators and why is Nethercott sitting in the board of PEMC? That is for coordination. Because sinabi lang po, sa PEMC bylaws, nilagay natin ang independent market operator president as member of the board para doon makakapag-report kung ano ang nangyayari sa merkado. Yun po ang purpose nun. And the other way around, it's the exchanges of information para nga po sa transition. At sinasabi ko nga po na ito naman po is transition na sasabihin natin, ano nga po ba ito sa 10 taon na hindi nagawa yan? Ngayon, ginagawa po natin dito. At sinasabi po, wala pa po naman 3 taon. We're still going into this into this thing, and including nga po yung sa budget. Yan, part of the transition po rin yan, and we are waiting for the Supreme Court decision. Although, DOE is the policy-making body that has been reiterated by the Supreme Court, and we said that if the market operator is already IMAP, if ARC will accept that and process the budget of IMAP, then the things will be clearer. But anyway, I will wait for the Supreme Court decision, Mr. Chairman.
Mr. Secretary, maitanong ko lang, kasama po ba kayo sa paggawa ng transition plan?
Paggawa ng?
Sa paggawa ng transition plan.
Ng
Transition plan.
Yeah, the transition plan, Mr. Chairman, Mr. Senator, is not made just by me. It is made also together with the stakeholders. So ako lang po ang nagganyan, hindi lang po ako nagkukanyan. No? They have to endorse that. They have to make that endorsement. Hindi
kasi kayo po ang bilang chairman dati ng PIMC po, kasama po kayo sa transition plan.
Ako diyan, kasi sinasabi ko nga po na to give independence na po para ang DOE makakagawa ng mas independent can also work. As bumitaw po ako being chairman ng PEMC po. Hindi na po ako naging chairman. Transition na yan. Sabi natin, tawag ko, IMAP, mag-create ang IMAP, ano po ako, and the transition, sila na po yun.
Kasama po kayo sa
assets na yan, sila na rin. And I have the bureaus, I have the directors looking at it. Hindi rin lang ako po ang tumitingin dyan.
With the kind indulgence of Senator Pacquiao, I just want to interject and share this. I just want to ask again, Chairperson Agnes, the DOJ opinion you're referring to earlier is the DOJ opinion dated February 24, 2012. Opinion to DOE, then headed by Secretary Almendras. Is that the opinion that you're referring to?
Yes, Your Honor.
Okay, and that is the opinion that you are abiding to insofar as approving the rates, the market transaction fees?
Yes, Your Honor. Until such time that it is changed, we are obliged to abide by that, Your Honor.
Okay. Let me just read the salient points of the opinion. Number one, no legal requirement under IPIRA to bid out independent market operator. Number two, no legal requirement under IPIRA to separate governance and operation of WESM. Number three, independent means independent of stakeholders. Number four, joint endorsement means endorsement of stakeholders as represented by the PEMC board. And then number five, DOE can legally appoint PEMC as IMO, independent market operator, provided it complies with IPIRA, IRR, and the WESM rules. Ito po yun. Is this the one?
Yes, Your Honor.
So it's clear, Mr. Secretary, that there is no requirement to separate governance and the operations. In fact, I subscribe to what Senator Pacquiao was mentioning earlier. In short, that there should be only one. But I think there is no debate on that because, Mr. Secretary, you said it's a transition. The question lang is how long is the transition? Because if you look at IPIRA again, since 2001, PEMC was supposed to be the transition. So it's been a 30-year transition already, and I think the transition should be should stop. No, in other words, should cease, and go back, revert to a single entity as an independent market operator. Because clearly DOJ shares the same. This is my interpretation earlier, and DOJ's interpretation of IPIRA clearly doesn't require a separate governance and operator of the WESM. It can be one and the same. And this is what Senator Manny Pacquiao was mentioning earlier. Now, why PEMC is still operating. And logic dictates that if you have two entities, you have two boards.
Naku,
Of course, my director's fee yan. You have two organizations that we have to pay. So that's additional cost for consumers. So my suggestion, Mr. Secretary, since you already mentioned that it's a transition, that to wind down the transition so that we revert back to the original intention of IPIRA to have only one entity. Yes, Senator Pacquiao?
Thank you, Mr. Chairman. Yan ang sinasabi ko, Mr. Secretary, na nandyan ka, pinagkatiwalaan ka, ilagay dyan para dapat ang interest mo para sa taong bayan. Ang itinitingnan natin dito ay kung paano natin pababa yung singil ng kuryente. Pero dito sa nangyayari, lalong tataas yung singil ng kuryente kasi yung isa naging dalawa. Isang trabaho, dalawa na ang nagsisingil. Nandyan ang PINSI, tsaka nandyan ang IMAP. So, sabi mo, transition, hanggang kailan ba yan transition? Katulad sinabi kanina, 3 taon na mahigit yan, Mr. Secretary. At gusto ko marinig ang sagot from you. Hindi mo pinaliwanag kung paano, kailan, sinasabi mo lang may transition plan. Hanggang kailan yan? Hanggang kailan yan? Kasi hanggat nandyan yan, isa yan sa nakakadagdag ng singilang nagmamahal yung singilang kuryente dahil nakikita ko, tina-charge niyo doon sa electric power industry, automatically ita-charge doon sa mga consumers, which is ang taong bayan ang magsasakripisyo. Sana naintindihan mo, Mr. Secretary, yung punto ko na ang tinitingnan natin dito kung paano natin pababain yung singilang kuryente. Baka aabutan na naman tayo ng bagong administrasyon. Yung sinasabi mo, tinatawag mong transition na yan. Sana gumawa po tayo ng solusyon about that. At gusto ko lang po marinig yung comment niya dyan, Mr. Secretary.
Yes, Mr. Secretary, I have the same question. Well, my suggestion is to wind down the transition, and then you may also respond to Senator Pacquiao's questions.
Suggestion, Mr. Chairman, Mr. Senator. Now, please allow me to say that Western rules allow a governing body, and that Western rules was created in 2001. Was made in 2001. It allows that, no. But anyway, what we are trying to do in this transition, yes, we want to wind down. We want to have one body transition, wind it down. But there is, you see, a lot of issues pending with the Supreme Court. And then we have this, even the budgets only being acted in now on of the Western. So these are part of the transition, all of these issues. Now, what I'd like to assure the good senator, Mr. Chairman, is that it's not costing the public. In fact, even in the transition that we made to bring it down, even with the two bodies, ito nga po pinapakita ko, na two bodies, in 2014, we have been spending already in market operation with one body, that is PEMC alone. They're spending 707,000 pesos a year. Now, with the two bodies, when we came in 2016, just stopping all the expenses that are not supposed to be there, it went down already to 659 million. And then further went down, with the two bodies, went down to 613 million. So what I'd like to reiterate, Mr. Chairman, is that there is no extra burdening of the consumers. Yes, probably we can still go down, no? The 0.0077. In fact, when we formed this transition, when we put this IMAP, there was already a problem because there was an attempt to increase it beyond 1 cent per kilowatt hour and follow the 2014. And I did not agree on that.
Mr. Secretary,
talagang ginawa po natin ito. At sinasabi po natin dito, hindi po yun ang rason. Kahit siguro po kung nagpabaya tayo, pinabayaan ninyo natin ang isang body, 707 pa rin hanggang ngayon. Two bodies, 600,000. So, that's not, kinuha ko lang po yun, i-reiterate ko rin yun because ganun din po ang passion ko. I want it to be cheaper for the consumer. So, the governing body is allowed. Opo, nagkakaroon po ng issue. Policymaker is DOE. We are doing that. And we are trying to make sure that the policy that we are doing will serve the people and the country well. So, yun po ang kwan po. And the DOJ opinion po did not lead to the creation of the IMAP po. It did not lead to that. Sinunod lang po namin yung sa independent market operator na magkaroon. So, sinunod po natin yan. And if,
Mr.
Secretary, talaga itong IMAP na ito tagal. At napakahirap naman na ako lahat po sumasagot itong IMAP na ito. Because the transition, sabi ko nga po sa inyo, nung magkaroon po ng creation yan, pinabayaan at saka sila na po ang nag-interact po dyan. Sila na po ang mga industry players in the IMAP. But at any rate, I'm willing to answer all the questions, Mr. Chairman.
Mr. Secretary, tatanong, gusto ko lang marinig from you, nasunod ba ang IPERA law o hindi? Dahil sa
I can assure you, Mr. Chairman, with all the lawyers that helped me and work on this, we followed the law, and that is what we are here for. Follow the law.
If we follow the law, the IPERA law, sabi ng IPERA law, pag nandiyan na yung IMAP, wala na yung PIMC. How is that, Mr. Secretary?
Because nga po, in 2001, when they created PEMC, they were supposed to create already the independent market operator in 1 year after. Hindi na po sana lumaki ang problema kung inaksyonan po agad yan noon. Kaya nga po, ngayon lang po, sinasabi, the political will to do it, we did it. Ngayon, 2016. Kung ginawa po yan ng 2001, yung mga sabat-sabat na problema dyan po, yung mga intricacies, yung mga lahat ng mga web of problems, hindi po sana nangyari yan.
Mr. Secretary, totoo po ba
Nagkakaroon tayo ng programming discussion eh.
Mr.
Dahil nga
Secretary,
po yung problema na ginagawa.
Mr. Secretary, totoo po ba na hindi nyo kinuha ang endorsement ng electric power industry participants sa pag-endorse mo ng IMAP?
Hindi ko po magagawa yun kung hindi po nagkaroon ng endorsement ng industry players. Sila po nag-elect ng kwan. Sila po nag-elect yan, hindi po ako. Sila po yun. Gumawa lang po tayo ng policy, ginawa lang po natin yun. Sila na po yun, hindi na po ako. So, the endorsement cannot, the formation cannot happen without the endorsement. Yung pagkuha nga lang po ng endorsement, medyo pa na rin po yun eh. Prosesong pan po yun. Medyo...
Bakit hindi nyo po kinuha?
Kinuha ko nga po.
Sabi
Kinuha
po,
ko po yung endorsement because that formation will not happen without the endorsement ng industry players.
Mayroon yun,
Ginawa ko yun. Approve po ng PEMC yun. In-approve ng PEMC. The PEMC po is in the industry players. Ginawa po nila yun. Meron pong endorsement yan. Kung wala pong endorsement yan, problema po. Yung problema pong malaki yun.
Kasi nga po binago dahil kasi nga po binago ang WISM rules, ikaw daw po ang gumawa ng transition plan.
Ang transition plan po was made by a task force, not by me. There are 5 people that were sa transition plan na yan po. Hindi po yan. That's why it's made by people that understand everything, lawyers and engineers.
Which was approved by the stakeholders.
Pero
pero
Mr. Secretary, chairman po kayo ng PIMC dati. Paano hindi kayo ang gumawa? Paano nalilito po ako diyan?
Kasi po ganito po yun, no? Nagkakaroon nga po tayo at that time when on 2016 when I sat at PEMC, nag-meeting po ako, sabi nga po natin ganito, how can we have an independent operation o tayo nandito? So it has to be kung bibigay ko lang po ang proseso na nangyari noon, it has to be handled by a private non-industry players. So kaya nga po napag-aralan din po yan na i-contract yung sa Singapore. Independent, kukuha tayo ng foreigner, but that will be very costly. So sa ganoon, nagkasundo po kami dito sa PEMC noon, sa board, gawa tayo ng transition body.
Mr. Secretary, linawin ko lang, sigurado po ba kayo na na-consult nyo ang API?
Sino po?
Sigurado po ba kayo na na-consult niyo ang API?
Ang IPIRA? Sorry?
EPI, Electric Power Industry, Mr. Secretary.
Yes, sir. Because sila po yung member ng PEMC. So sila po yung gumawa kami ng transition. Yun na nga po ang ginawa. And then this transition plan was submitted to them for their endorsement. And then they made their endorsement together with the experts of DOE. So ganun po yung...
Pwede po makahingi ng yung endorsement nila, Mr. Secretary, yung sinasabi
Yes, sir. Yeah, we will provide that to you. We will provide you all the documents without hesitation po.
Kasi ikaw ang nag-endorso ng IMAP eh.
Policy po ang ginawa natin, ang endorsement po ng IMAP, DOE and po yan, yung sa industry players.
Public consultation.
And public consultation.
Totoo po, ikaw po ang nag-endorso ng IMAP.
Mr. Chairman, pati po yan, it went under public consultation. The transparency in doing that was done before a department circular was issued. The department circular na ginawa po natin, inaprubahan ko po, sasabihin ko, inaprubahan ko, went under public consultation.
Kasi po, Mr. Secretary, ito, sa tapatan tayo. Inendorso mo yung IMAP, inaprubahan mo yung IMAP, na hindi siya qualified doon sa requirements ng IPERA law?
We have the we have the department, kami na po may mga policy na ginawa na nakakasiguro po ako na yan pong IMAP is compliant sa requirement. Yan po ang talagang kasi kung
Paano
hindi dami pong gumawa niyan.
Mr. Secretary, linawin ko lang para hindi tayo humaba pa. Para hindi tayo humaba pa. Sabi mo qualified ang IMAP na i-endorse mo, ang IMAP 7,000 capital. Ang IMAP less than wala pang 2 years ang experience, which is one of the requirements of IPERA law. Tapos kinuha mo. Tanong ko lang para malinaw lang talaga ang gusto mo lang. Bakit niyo napili ang at hindi niyo po sinunod yung IPERA law requirements?
Gladly, Mr. Chairman. When we were doing all the study, the transition plan, IMAP was not yet appealing. Wala pa po ang IMAP. Wala po yung IMAP, no? Ang ginawa ko lang po, I signed the policy, ang policy. And then hindi ko po dinesignate ang IMAP. Hindi ko dinesignate ang IMAP. Hindi ko po dinesignate yan. Ang IMAP po, ginawa na lang yan na para sila po na magkakaroon sila ng body that will handle the market operation. Kaya nag-form po ng non-profit, non-stock.
Mr. Secretary, ang tanong ko kasi bakit nakuha itong IMAP na hindi siya qualified doon sa requirements ng IPERA law? Yun po ang gusto kong malinaw na sagot, Mr. Secretary. Pasensya ka na kung makulit ako dyan kasi hindi kasi ako satisfied doon sa mga sagot mo na explanation mo. Kahit maiksi lang sana, basta masagot lang yung ko.
I appreciate your question.
Mr. Secretary, sana maintindihan mo yung ibig kong sabihin na kailangan ko lang malaman kung anong mayroon ang IMAP, bakit kinuha ito, hindi ito pumapasa doon sa qualification ng IPERA law. At ang IMAP, ang isa sa board ng IMAP is yung asawa ni Attorney Matibag na sa iyo nagtatrabaho.
May I answer, Mr. Chairman? May I be recognized?
Yes, Attorney Matibag, go ahead.
Yeah, Mr. Chairman, alam mo, kanina pa ako nakikinig I even watched the video of Senator Pacquiao. I hope this is not covered up in immunity Unang-una, Mr. Chairman, yung mukha ko ipinaster doon, pinanggit doon. I want to know, ano ang kinalaman ko at non-trans ko doon sa PEMC at IMAP? If Senator Pacquiao only read the IPERA law, buong kwento dito Trans ko noon ang operator muna bago nag-PEMC. At tinransfer yan sa PEMC. Wala na trans ko dyan. Alam niyo, let's call a spade dito sa hearing na to This is all political, Senator Pacquiao. Alam naman natin to, ito yung pinapasabi mo nung bago ka umalis Nung umalis ka, na sinasabi mo, meron kang pasabog. My wife is an incorporator, an independent incorporator.
Attorney Melvin Matibag.
Attorney Matibag, Attorney Matibag, can you
waive your immunity.
Attorney Melvin Matibag.
Attorney, hold on, Senator Pacquiao, Attorney Matibag. This is my committee, and you have no right of calling this hearing a political hearing. This is a budget hearing. The senators are entitled. The senators are entitled to ask policy questions. So you have no right of calling this a political hearing. You're out of order. You're no longer recognized. We've given you a chance to answer the policy questions, but instead, you insulted this committee by calling this a political hearing? Hindi naman fair yun.
So, Mr. Chairman.
Yes, go ahead, Senator Pimentel.
So you have declared Attorney Matibag out of order. So how do we implement it? We keep him muted for the rest of the meeting?
Yes, we keep, well, you should leave this hearing.
Okay.
So we will now, remove him from the WebEx list. So I'm directing the committee secretary to remove Attorney Matibag from the list here in WebEx. He's out of order.
Mr. Chairman, sorry for that. Bastos itong si Attorney Matibag eh. Sayang yung pagka-lawyer niya, eh parang walang pinag-aralan. Pinagmamalaki na matalino, pinangyayabang pa niya na mas matalino siya, pero dito sa attitude niya eh hindi kagalang-galang, wala parang hindi nakapag-aral, Mr. Chairman. Sorry to my word, but yan ang totoo. Dapat magpakita naman ng paggalang. Eh, akala mo kung sinong matapang. Eh, pala naman siguro niya, tatayo yung balahibo ko sa kanya.
Anyway, Senator Pacquiao, like I mentioned before the hearing, the budgets of DOE, ERC, and NEA are not substantial compared to other agencies. That's why I expect a lot of policy questions that will be asked, because the budget itself is not as much compared to the other agencies. So I enjoin the departments here, DOE, ERC, and NEA, to respond to the policy questions. Some of the policy questions might be complicated to propound, but the senators are, it's their right to ask questions, and it's their right to drill into the details of different issues. So let's give everyone the opportunity to ask. And I thank Secretary Cusi for patiently answering, and I can see that he is really trying his best to answer the question as a gentleman and as patient as possible. And I commend him for that. It's part of the public hearing. And what we don't want is insulting this hearing, calling it a political hearing. This is not a political hearing. It's a budget hearing, and we allow policy questions to be asked. So go ahead, Senator Pacquiao.
Thank you, Mr. Chairman. To Secretary Jose, huwag po kayong mainit, huwag po kayong magagalit sa akin. Katulad nung ginawa ni Attorney Matibag na nagagalit siya, nagtatanong ako ng question. Medyo bastos. Nabastusan ako. Parang walang pinag-aralan. Mr. Secretary, gusto ko lang pong linawin doon sa mga tanong ko kasi may mga tanong ko kanina na hindi po malinaw ang sagot. Especially pagdating dito sa PIMC at saka IMAP. Yun pong tinatawag nating transition. Hanggang kailan po ba yan? Transition na yan? At patapos signal po ako nga. Gusto ko lang pong malaman kung kailan matatapos yan kasi 3 taon na yan, transition na yan. At yung member ng PIMC nandoon din sa IMAP. Ano po yan? Kaya po tayo kumuha ng independent body list ng IMAP at based doon sa requirements ng IPERA law.
Okay. Thank you, Mr. Chairman. Thank you, Mr. Senator. Well, I have to apologize for the interruption, and if you are offended by Attorney Matibag, I have to make that apology considering that he comes from the DOE family. So my apologies. But anyway, to answer your question, Mr. Chairman, hanggang kailan po ang transition na ito? Katulad po din natin, na gusto ko na rin pong matapos itong transition na ito. Na sana po bago matapos itong termino namin, matapos na. Kaya lang po, there are things that are beyond us. No? Hihintay ko rin po yung Supreme Court decision dahil kinwestiyon nga po yun because ERC did not take the policy and the question of law, issue of law. So nandun po yun, hintayin po natin. But I hope that I can finish it before my term ends, Mr. Chairman.
And also, Mr. Secretary, sana sundin natin yung IPERA law. Isa na lang ang, kung nandiyan na yung IMAP, wala na yung PIMSI.
Mr. Chairman, I can assure you that we follow the law to the best of our abilities. That's why I always consult lawyers. If there are things that you think that we need to look at, just let us know and we will be obliged to study. Thank you, Mr. Chairman.
Gusto ko lang rin pong malaman kung kasi hindi po malinaw kanina yung sagot ninyo, yung saan po kinukulikta yung charge ninyo sa sinasabi mo yung sinasabi mo sa electric power industry china-charge. Totoo po ba yan?
Market fees po, market fees are being charged or collected from the market participants. Sino po itong market participants? Ito po yung generation company, yung nagkuha ng electricity po, nagbebenta ng electricity. Ito po sa kanila china-charge yun. So, kung magkano binebenta ng Genco yung electricity to the consumers, and then plus, including the transmission, yun po ay sama-sama na po ron. Dahil sina-charge po sa consumers.
Ang tanong ko, Mr. Secretary, yung market transaction fees, saan po sina-charge yan?
Yan nga po, ang in-charge po dyan, sinabi nga po kanina, natanong na rin po sa ERC. Ano po, ERC look at the charges and this is being charged to the GenCos. Ano po, kung sino po. Kasi ang GenCos po, marami po yun eh. So kung ano na-dispatch nila, nabenta nilang punto kuryente, yun po ang natacharge ng market fees. So eventually, this goes to the total bill being presented to the consumers po. Kung Meralco, nasa Meralco bill po yun. Kung sa other utilities, ganun din po.
Maraming pong salamat, Mr. Secretary, at pasensya na rin kayo dahil buti lang napigilan ko sarili ko rin doon sa kay Milvin Matibag. Nag-interject sa atin usapang IPERA law yung pinag-usapan natin. Hindi politika. Ito ay budget na kailangan natin i-approve sa lalong madaling panahon dahil kailangan ng taong bayan. Especially ang tinitingnan natin dito is mapababa yung gastusin ng ating bansa. Kasi kung titingnan po talaga po natin, masyadong mataas yung gastusin natin. Ngayon, 2022 ay 5.3 trillion. Pero kung ang income ng ating gobyerno, Mr. Secretary, hindi pa umabot siguro ng 3 trillion. So, kaya tayo nandito, nag-cross-examine sa budget. Tatanungin natin, sasalain natin para maging tayo conservative sa paggastos, no? Dahil palaki yung budget yung income ng ating gobyerno, revenue income ng ating gobyerno annually hindi enough to cover up the annual budget. That's why we cross-examine all the budget proposals ng iba't ibang ahensya ng ating gobyerno. And yan yung gusto kong maintindihan din sana ng iba. Hindi ko alam, Mr. Secretary, na nag-interrupt itong si Matibag. Hindi naman tayo magkikipag-away dito, kundi ginagampanan natin yung trabaho natin. And I hope that you will understand that, and you understand that, Mr. Secretary. Ang pinaka-concern natin dito, hindi ito pamulitika dito. Ang budget ng bansa ang pinag-usapan natin dito. Katulad nung sinabi ko, nasa 5.3 trillion ang budget proposal ngayon, Pero kung titingnan po natin yung income revenue ng ating gobyerno, mas pasalamat po tayo kung aabot ng 3 trillion. Baka hindi pa po umabot ng 3 trillion yung income ng ating gobyerno. Tapos ang budget natin, ang gagastusin natin for 2022 is 5.3 trillion more or less. Yan po, kaya nandito kami mga senador para salain, busisiin yung budget proposal ng bawat ahensya dahil sa lumalaking budget at lumiliit yung income ng ating gobyerno. So, very conservative po tayo dito sa pagdating ng budgeting dahil taong bayan po ang magsasakripisyo. Ang Pilipinas natin, mangutang na mangutang, mababaon tayo sa utang hanggang sa kahulihan. So, I hope that everybody will understand that na kailangan nating makialam, tanungin, yan po ang ating responsibility sa taong bayan. Maraming salamat, Mr. Secretary and Mr. Chairman.
Thank you, Senator Manny. And I thank the good secretary for patiently answering the questions of our senators. A lot
Chairman.
of these questions are policy in nature, so thank you very much for that. Yes, Senator Pimentel.
Mr. Chairman, is there another hearing for the budget of the DOE? Because I need to leave because of a very important briefing on a very important treaty, the RCEP treaty to be given to me by the DTI. Sana marami pa ako itatanong about unobligated amounts, yung accomplishment report nila, Malampaya. How about connecting the grid of Mindanao to the rest of the country? At saka yung e-trike project, kung nababanggit pa ba yan sa COA report nila. Tsaka although maliit lang yung budget nila, 1.255 billion, meron kasing earmarked revenues of 61 billion over the years 2020 to 2022. So kung pwede pang magtanong doon, Mr. Chairman, but I just have to leave right now. So is it possible to have another schedule for the DOE?
Upon your request, it's possible, Senator Pimentel. By tradition, we try to finish these agencies in one day, but frankly speaking, this is the most senators that I have encountered in the budget of DOE, ERC, and NEA. Normally ho, ako lang mag-isa nagtatanong eh. Pero this time around, a lot of our senators took interest. And it's a privilege for me, to have a lot of our senators looking at the budget. So upon your request, we will have another session. Of course, we will consult the good secretary and yourself with the regarding the schedule.
Thank you, Mr. Chairman. So magpaalam na po ako. Salamat po sa lahat. Thank you.
Mr. Senator, maybe if possible, so as to save on time, if you can just give us the questions of the good senator, I'll be happy to answer all of them in writing, Mr. Chairman.
Yes, Secretary, we will request Senator Pimentel's office on their questions. I think he gave us a glimpse of what he want to propound on, but we will request for an advanced copy of those questions so that you can prepare and we can have a smooth hearing later on. So with that, I'm looking at the screen if there are other senators who want to ask. If not, Mr. Secretary, I'll go to my questions, and these are, I think some of these questions are probably related to what Senator Pimentel wants to ask. I'll go to the budget proper, Mr. Secretary. And I looked at the obligation rate and disbursement rate of DOE over the years, And from 2017 to 2019, the disbursement rate was only 45% for 2017, 56% for 2018, and 49% for 2019. In fact, this year, in 2020, it's even lower, no? Obligation rate of 72% and disbursement rate of 66%. This year, as of June of this year, the obligation rate is only 22%, no? So, and disbursement rate is 71%. So, everything is, in short, the disbursement rates and the obligation rates are quite low compared to the targets of 90 and above. So may we inquire from the good secretary on how come it's traditionally quite low, the obligation and disbursement rate? And then second, what is the department doing to improve the disbursement rate and obligation rate? This is these numbers are important because it's a sign of efficiency. And obviously the disbursement and the obligation efficiency is not there. No? So maybe ask what happened there and what are the remedial measures that you are putting in place?
Yeah, thank you, Mr. Chairman. First is in the 2020-2019, that is that is 2021. Our disbursement, especially 2020-2021, disbursement rate is low because of the pandemic, and as reported in the budget, around 212 million, 212 million we returned in 2020, gave it back to the Treasury to help in the COVID fight. There are things that there are projects that were suspended or travels that were not made, meetings that were not held. So that the disbursement is really low. Now, even here in the 2021, our disbursement in the first half is low, but now in this second half, we are facilitating everything. So, and we want to be prudent also in the use of our budget. On the previous years, 2018, why it's low? Because the 500 million pesos that is supposed to be used for rural electrification that we were supposed to download to NEA did not materialize because of certain accounting and audit requirements. So hindi po natuloy yun. And again, we just don't like to disburse it also without following the rules. So we were just prudent in doing that, and you will see now that the budget is really trimmed to the very low. No? Our budget has been going down, so those things that sabi nga po ni kanina na kailangan we have to be frugal and kailangan na tama lang, minimum lang. Yun din po naman ang ginagawa po natin, Mr. Chairman.
Secretary, I just want to flag the department. No, even prior to the pandemic, if you look at the disbursement rates, it's very low. No, even the obligation rates are just hovering around 70%. No, and the Senate is quite strict with this. I know Senator Risa agrees with me, but we're very strict with this utilization of funds. So and then in 2021, which is this year, even middle of this year, the disbursement rate should be around 50%. So, in other words, Secretary, the efficiency of utilizing the funds is quite low. No? And I just want to flag the department on this issue. And for 2021, just submit to us, no? Ask your team to submit to us a catch-up plan, no? Because we need to catch up. Ang baba ng obligation rate, it's only 24%. And this is something that our senators really monitor, no? So just submit to us a catch-up plan on that.
We do, Mr. Chairman, I have discussed this also with my people here, and we will submit it. Thank you, Mr. Chairman.
Thank you, Mr. Secretary. Another issue, Mr. Secretary, is the NEPIO, or the Nuclear Energy Program Implementing Organization. No? And over the past few years, we have supported this program. I personally supported the research of nuclear power in our country. I know nuclear power is controversial, it's risky, but it's important for our country to look at this objectively and to use science as the method to decide whether to go or not to go into nuclear. That's why since 2018, the Senate has been funding the research of nuclear energy. To date, we have already allocated 266 million for the research of nuclear energy. And I just want to get an update, no? Because we already allocated substantial amount. Number one is, what's the latest on this nuclear research? These amounts are actually meant for research, so that our decision-making point will be based on science. So we just want to get an update on how this money was spent, ano ang resulta, what are the results of this research, and considering that in 2022, another 25 million is being requested. So we want to get an update on the nuclear research activity of the department.
Mr. Chairman, thank you again. The output of all of these things are already submitted to the Office of the President, and that is with a prayer for the inclusion of nuclear in our energy mix. And there is a proposed national position already for with regards to nuclear power. So all of this, that's the output already. It's there already that we submitted it early this year or December last year, and we are just awaiting the approval of OP. Now, the money has been, as you've said, for research, and this is spent with the meetings with Nuclear Atomic Energy Association, and then the visit in the different plants, and the visit here of the experts in the Bataan nuclear power plants, and the studies that we have made to come up with the output study, and that resulted to our recommendation to the President.
Secretary, is there some form of an output on how the President will be guided on his decision? I understand from last budget hearing, I remember during the last budget hearing, that the President will decide last December. In fact, I remember that. But obviously, no decision was made. So, what is the output of this 266 million by way of research? And may we request for a document of that research, no? Because we want to see how the research was conducted, what are the challenges, and what are the recommendations. And these recommendations will be used by the President to decide, no? So may we request that for that output, for that documentary, for that document, which contains the research and recommendations.
We're happy to provide that, Mr. Chairman, with the timeline when this was the different meetings, consultation, and studies were made, and we'll gladly submit it to you. And the output that we have done is that we have already, one of the output that we have made is that the proposed EO has been submitted also to the President, and also the legislative requirements to make nuclear part of our energy mix, Mr. Chairman.
Mr. Secretary, realistically, of course, we're all ending our term. I'm up for re-election, and the administration is also ending its term. We all know that nuclear is a long-term endeavor. Even though we come up with some form of decision now, we will not see it. I might not see it, or you might not see it. So, realistically, Secretary, what is the game plan? No? Will this research be carried over, and will this research be something that the next administration can use? And if ever the President will decide, because I understand the the most important part now is the decision of the president. If ever the president will say yes, realistically, when will we see this happen?
You're right, Mr. Chairman, that our term is ending, and we are laying down all the foundation to for the inclusion of the nuclear in our energy mix. Our vulnerability on all the things that are happening, the pandemic and the oil and the supply chain, is very serious, and we cannot ignore it. And we need to have that energy security, and nuclear will assure us of continuous operation, at least for a certain period of time without without interruption. Of course, there are technical requirements to make that happen. So what we are doing is that, are we going to see it? But I think the foundation is to be laid down. The studies have been made. People acceptance have been calculated already. At least 70% of the people that we have consulted favors the inclusion of nuclear. On the research on the other areas where we are going to put it, we have identified the areas. Now, whether the next administration will be receptive to it, that I will not be able to answer. But I think if the legislative can just pass the law, including the laying down the foundation of the inclusion of the nuclear, then I think it will be easier for the next administration to make things happen, Mr. Chairman.
So, Secretary, part of the output from that research are legislative proposals.
Yes, sir. Yes, sir.
Well, we're open to looking at those legislative proposals. Obviously, I might not be the one who will pass it because of my time, my term, when I'm up for re-election. But nevertheless, it's good to study those, and if warranted, we can even file it, at least to get some feedback on that. But in short, please submit to us those legislative proposals. It will be more helpful if those pieces of legislation are already crafted, so that we will not write it anymore. You have your legal team to put that together, and we will take a look.
Yes, sir. We'll do that, sir.
Thank you, Secretary. Another thing is energy efficiency, and this is an exciting industry. But frankly speaking, no, I'm very excited with this because it's a rising industry. It's a new industry. I've talked to some of the practitioners, and they're getting their acts together. So I'd like to get some updates on energy efficiency, and let me just show. I commend Director Patrick Aquino for his quite regular update, for regularly updating us. And I commend the department that even during the pandemic time last year, you've managed to release a lot of circulars that will implement energy efficiency. And I commend the department for that. However, there are still some items that are not operationalized, and anyways, while we look for the slide, but we would like to get some updates, Secretary, on energy efficiency, and what are the items that are not yet operationalized, and when we see it operationalized.
Thank you, Mr. Chairman. Just as you've said, that even during the pandemic, the team worked hard on all of these things. The issuance, there were 11 issuances, memorandum order or department circular or department order that was made. Now, there is another one that is on the resolution published on April 19, which we direct all government entities, including LGUs and foreign service posts, to use energy-efficient light emitting diode. No? So this one is we need higher compliance to this, and we are auditing the compliance of all government offices. So Of course, this another one is the including the local government unit. So this energy conservation, as I have presented, what energy conserved is energy produced. No, and we have something like I said, I think 170 megawatts equivalent energy savings that we have made over 20, 2020. Was it, am I right? 2020, well, 100, oh, sorry, 182, 8 or 12. The 2020 is 171 billion pesos savings equivalent in energy cost, Mr. Chair. So I think it's on the screen right now, the different circulars that have been issued, department orders or memorandum circular. Pending items on EEC ACAR on the waste management and recycling. Yun po ang isa pang kulang na ina-address natin. And in fact, our USEC Pusadas had an interaction with USAID regarding the implementation of the waste to energy. We're talking of the municipal waste and we are coming out with the policy. I have given the order already on coming out with this policy on the energy, waste to energy. So I hope that we can have this by next year or before our term ends. No. So we are also public consultation scheduled for public consultation for the National Energy Efficiency and Conservation Plan with set targets across sectors. So yun po ang mga napipending na gagawin pa namin, Mr. Chairman.
Yeah, Secretary, I just want to flag the department again on some of your programs. No, I saw in the budget the low disbursement obligation and disbursement rate. No, this is from the COA report. For example, the National Energy Efficiency and Conservation Program, in which it has zero disbursement rate. And then when it comes to the NEPIO, the Nuclear Energy Program Implementing Organization, you see there's very low obligation in disbursement rate. And then, of course, the total electrification program, the obligation rate is only 1%. So I just want to flag the department on these very low disbursement rate by program. And these are very important programs. Like, for example, the Energy Efficiency Conservation Program. It's a very exciting program. A lot of people are excited about it. But the sum that we allocated is not disbursed yet. No. So I just want to flag the department on this. This is 2020.
Yes, yes, Mr. Chairman. That's why on the total electrification project, there was really a delay because of certain issues, auditing issues, and the money that was supposed to be used by NEA, we have to get it back because of certain COA requirements. So we were not able to disburse that. And but this is what we are working now. We are really working double time on total electrification because we know that our term is ending and we need to accelerate the household electrification. So on the on the nuclear energy implementing organization, there were just some certain activities that was not carried or was carried but spent lower than we budgeted, Mr. Chairman. That's why our budget even went down for NEPIO on this year, went down to 25 million, no? So with regard to NEC, dito sa National Energy Conservation, I think there are some details that we are looking at. Last year we have addressed, but we will include the details when we this in writing, Mr. Chairman. I just don't have all the details right now.
Yeah, just submit to us, Secretary, those details. On the electrification, Mr. Secretary, I know that there were issues with COA, and apparently DOE cannot download to NEA those funds. However, and that's reflected here, no, on the total electrification. No? You couldn't use the funds. However, in 2022, next year, you allocated again 315 million. So have you resolved this issue? Can you download to NEA? Because I know for a fact that the total electrification of DOE is being downloaded to NEA. And I can see that DOE has programs, but NEA is the implementing arm. No? So have you resolved this issue with the COA?
Yes, Mr. Chairman, and I have issued already the guidelines, and actually they are in the process of procurement already on with regard to the subject, Mr. Chairman.
So you can download already, Mr. Secretary.
No, but we're not downloading it anymore to NEA, Mr. Chairman, but we are doing it together with the LGU, Mr. Chairman.
For the 315 million, it will be a partnership between the DOE and the LGU?
Yeah, with the DOE, principally it's a DOE, Mr. Chairman, but of course in coordination with for the beneficiary, the LGU, Mr. Chairman.
May you, Secretary, in a nutshell, not because this is the first time I've heard of that program. In a nutshell, how is that program going to be implemented? No? Because I understand before NEA, it was through NEA because part of NEA's responsibility is rural electrification. But in this particular case, the title of your program is total electrification. So how can you describe to us this new program between the LGUs?
We're looking at, of course, we're prioritizing the people that are on the remote areas that cannot be reached by the distribution line or by the easy services. So there are still a lot, and we need to provide them the electricity that can help them in their for the children, for their communication, especially in this the distance learning. So we have this standalone for the household electrification, and then the QTP for the certain community depending on the number. So in the remote areas, especially the mga IPs, standalone na ibibigay po natin, Mr. Chairman.
So this will be solar home systems?
With the solar home system, Mr. Chairman.
And how many beneficiaries do you intend to give this system?
I don't have that in my head, Mr. Chairman. But if you will allow me to let the bureaus to answer that, I will happy answer that. No, how many the numbers of beneficiaries? Provide that to you, Mr. Chairman.
Yes, just provide us the target. But I understand, I'm looking at your budget right now. No? There is a 180 million for solar home systems. This is to give 10,000 homes. No? Iba pa po yung 315 million. So I'm trying to understand how this 315 million will be spent, no? And what type of program. Is it going to be the same solar home systems?
No, not.
Mr. Chairman, if I may.
Yes, Senator Risa, go ahead.
Salamat, Mr. Chairman. Dagdag lang dun sa tanong ni Chairman, Secretary, yung binanggit ni Chair na solar home systems, yun din po ba yung para sa mga informal settlers na marerelocate sa mga social housing facilities or iba po ba yun?
Iba po yung sa mga social housing facilities, Mr. Chairman, iba po yun kasi it's a community, so a QTP will be or microgrid will be more adaptable, Mr. Chairman.
Salamat, Chairman.
So, Secretary, itong 315 million will be partnered with the LGUs. And just in a nutshell, no, just describe to us how will you implement this with LGUs will select the beneficiaries. How do you plan to implement it?
Just a minute, Mr. Chairman, trying to
Yes,
get
yes.
the things.
No problem po.
But if you can proceed with the other questions, we can come back to that later,
Sige
Mr.
po.
Chairman.
I'll go to renewable energy, Mr. Secretary, because this is one of the things that is for a long time pending, and there are unimplemented, very important policy tools that you can use to push RE. Let me just flash it on the screen so that. So for example, natanong na ho kanina ito ni Senator Risa and Senator Marcos. These are the policy tools that are not yet implemented. No? Sorry for the malabo. Number one is renewable portfolio standards for off-grid. It's not yet implemented. On-grid, we're fine with that. Off-grid is not yet implemented. The green energy option is not yet implemented, but I know registration is ongoing. The Renewable Energy Trust Fund, not implemented. The REM, the Renewable Energy Market, is not operational. And there are still some issues on taxation, no? Zero VAT purchases, the green energy policy, the green energy auction policy, the green energy option program, hindi pa ho implemented yan. And lastly, the implementing guidelines on the trust fund. No? So maybe get some updates on these very important policy tools because most of these are in the law. No? And we all know the law was implemented in 2003, 2008. But some of these very important policy tools are not yet implemented. So maybe get an update, just a quick update po on these policy tools, no, one by one. Like for example po yung RPS off-grid. When do we see the implementation of that?
The RPS off-grid, admittedly, we are behind our schedule here because of a problem with the ECs on the contracting capacity because it's a complication of issues. Some of them are already over-contracted, and a lot of things are going on. And we will, yes, we will. We need to push this. On the RPS, on grid, that is going. On the net green energy option, as you have mentioned, that this registration is ongoing. On the green energy option, all the policies, all the circulars are done. It's a question of doing it now. And there are all other green energy options. Yeah, I mentioned that already. That energy is ongoing. The market RE market RE market that is also in process. In fact, one issue there is that should it be with IMAP or PMC? And I made that decision already that this has to be the independent market operator. That's done already. So, and there are other things. And if you wish, Mr. Chairman, I can write you all the updates on what you have planned on this.
Yes, Mr. Secretary, yes, please submit to us a detailed implementation of these remaining items. A lot of our stakeholders are waiting for the implementation, and I'm hoping, and I'm really strongly suggesting that to fast track the implementation, because it's been quite a long time since we implemented the RE law. Just to go on some of the important items, Mr. Secretary, the zero-rated VAT and corporate income tax. No, I conducted a technical working group between the BIR and the RE stakeholders, and one of the solutions that they see is to amend the IRR, no, which the department crafted. So I just want to get an update on that, Mr. Secretary. Where are we in terms of amending the IRR so that we can implement the zero-rated VAT and the corporate income tax due to the stakeholders of RE?
Yeah, can I have that? Can I have it? Sorry, Mr. Chairman, I just have to get some inputs on this this thing. There's just an update, Mr. Chairman. One provision is still, just one last provision that is still being discussed with legal services, with our legal and R&D on this zero VAT on RE, Mr. Chairman.
Can we get that amendment within the year, Secretary? So that we have some good news for our RE developer. The BIR is fine. During our technical working group, basically what they said, they're just following the IRR. So we'll go back to the IRR of the RE law, which the department crafted. No? So is it possible to get that amendment within the year?
We'll work on it, Mr. Chairman. Please take note of it. We'll work on it, Mr. Chairman.
Thank you.
Yes,
Thank you,
immediately.
Mr. Secretary. Thank you very much. And lastly, before I turn over to Senator Risa, and this was opened by Senator Risa earlier, and this is actually the biggest elephant in the room, is the case of Malampaya. No? Senator Risa started asking about that. I just want to be clarified, Secretary. This transaction between Chevron and Odena, does the government need to approve it first before the transaction gets consummated? We need to put this foundation in place, because I'm getting mixed signals and mixed answers from the department. So I want to ask the secretary himself. Does this need government approval before it gets consummated? It's a fundamental question, Secretary.
In the case of the sale of Chevron to to Udena, it doesn't have to get prior approval before it is consummated. That is unlike.
Secretary, you're in mute. So, sorry, can you repeat that? Naputulo kayo.
Hindi na po kailangan. In the case of the sale of Chevron to Udena, hindi po kailangan ng prior approval by DOE before they consummate the sale, Mr. Chairman. Ang iba po yung sa kaso ng Shell. Iba po yung kaso ng Shell. Because in the sale agreement, clearly provided na kailangan po ng prior approval ng DOE. Kaya nga po, sinasite ko, Mr. Chairman, yung mga previous transaction on the sale between the name of Occidental exploration and everything. It didn't go through the process, and the sale did not go through DOE. So hindi na po na yun. Ang pag hindi po nagmatch ang PNOC at saka yung yung Shell at the time, that was presented to us. Actually, when they reported, when Chevron and Udena made the report to DOE, informed the DOE, tapos na po yung process ng kanila, ng bentahan nila.
Secretary, this was I asked this question during our hearing last year, November 10, and I requested for an official answer, and we were given an official answer by the department, contrary to your statements. And let me just flash it.
Kasi wala pong wala talagang provision, wala po talagang specific provision or law that would say that it requires a prior approval of DOE. Ang ginawa lang po ng DOE is to make sure that we don't compromise the energy security of the country. So kaya nga po yung tiningnan natin, yung legal, technical, and then yung financial capability of the company. No, pero yung company na appraise namin po, yung talagang Chevron pa rin ang nangyari doon. Yung buyer, Udena, I think they were vetted differently by the buyer. So ganun po yung pangyayari doon.
But Secretary, when we had this hearing, Senator Risa was there also during that hearing. We asked the same question to ASEC Pulido. Kailangan ba ng government approval? Because it's a fundamental question. So basically, this is what he answered, no? And let me just read it. So back in March 2020, a letter was received by the Department of Energy, which informed us of the completion of the transfer shares, which allegedly occurred on March 11, 2020. The Department of Energy endorsed this letter to our Legal Services Department, wherein our legal services had to determine whether or not such transfer would fall squarely within the ambit of the department circular that would require the Department of Energy's approval of the transfer. And our legal services held that it falls squarely within the department circular, that it should require an evaluation of the technical, legal, financial capacity of the transferee so that the department may approve such transfer. And then I go on to ask, no? I asked ASEC Bodi. I said, ASEC Bodi mentioned that the sale is governed by Section 11, which is PD 87, which is in your screen right now. It's very clear in Section 11 PD 87 that you cannot transfer or assign your rights without prior approval of the DOE. Does this still hold, Yusek Marcos? I think it's Yusek Marcos here, no? Does this apply to the transaction between Udena and Chevron? I asked Yusek Marcos first, and then Yusek Pulido, and then he answered, yes, Mr. Chair. So I clearly asked, no, does this apply to the transaction between Udena and Chevron? And then after that, they sent us a letter. No, this is an email submission to us, no, because we told them to justify, no, their answers. In that red bar, you can see, and let me just read. However, prior to approval by the DOE of the said SPA, we are of the opinion that the same is not binding to the government, as represented by the DOE, as PD 87 itself requires. As PD 87 itself requires prior approval before effectivity of any such transfer of rights and interests. Regardless of the nomenclature, the SPA entails a transfer of rights and interests in SC 38. As such, approval of the DOE is necessary before such transfer becomes effective. So in other words, during the hearing, they mentioned that prior approval of DOE is necessary for such transaction. They sent us this document through an email dated November 17, 2020. And this forms part of the committee records. Yan po yung email. So, Mr. Secretary, what ASEC Pulido and the submissions to us are saying that it requires government approval. So this is where the confusion comes in. So that's why we're confused.
That is the reason, Mr. Chairman. That's the reason why we are acting on this transaction despite the sale of shares, which is not covered by our rules and regulation. That's why I also said earlier, sa farm-in, very clearly, we need prior approval by the DOE. But in this case, share sale is different, and therefore it does not need prior approval. And basing on the previous transactions that have happened in the past since 1990, Mr. Chairman, it's true that that's why our people, the DOE, has been saying that we went beyond what is required of us by even weighting the technical, financial, and financial, and legal capabilities of this transaction. So we went beyond. Yun ang naging problema. We went beyond that one, and we evaluated it. Farming sana, wala, klaro-klaro po. But on the share sale, wala po sa regulation na yun eh. And then we're looking at the corporation law, and I asked the legal, ano ba to? And after all the studies, you know, the corporation didn't change. It's only the stockholders that change. So when we look at the technical capability, pareho pa rin. When we look at the financial capability, pareho pa rin po. And that it is legal. So sabi namin, we cannot really oppose the sale. So we went beyond that, Chairman.
Mr. Chairman.
Senator Risa, go ahead.
Thank you, Mr.
Senator Risa.
Chairman. Salamat, Mr. Chairman. Yung pinaalala po ng Chair of the deliberations in that hearing, yung sagot po ng legal mismo ng Department of Energy, and then followed up by the email of DOE Legal to the Chair. Napaka-importante, Mr. Chairman, whether what transpired or what is transpiring is a farm-in or not, whether or not it is a certain kind of transactions on the shares or not. What stands out, Mr. Chair, is that may opinion ang DOE Legal na kailangan ng permiso ng DOE. And they even put that in writing through that email to the Chair, which makes me wonder, Mr. Chairman, if it is proper at least to raise the policy question, if that transaction can be caused to cease and desist, or if the transaction can be reversed, if a higher national interest can be shown to be at stake, Mr. Chairman, starting just from the very important point that DOE Legal says that in terms of the process, dapat sila ay papayag or hindi papayag sa ganyang transaction, Mr. Chairman. For the record po.
I agree, Senator Risa. And just to continue, we requested submission of some documents from the DOE. This is after our hearing, Senator Risa. You were there actually all the time, no? So, we got this document. This is a document from the DOE's legal services through Assistant Secretary Ergiza. And this is for the Secretary. And if you look at the bar again, no, this is the legal basis for the review. Inasmuch as the SPA involves a transfer of interest in SC38, the same must be approved by the DOE before it becomes binding and effective. In accordance with Section 11 of PD 87, this is the guiding law as amended. In relation to DC 2007, this is the implementing circular of the guiding law, which prescribes the guidelines and procedures of for the transfer of the rights and obligations in petroleum service contracts. Likewise, there was a transfer assignment of interest in SC38 is evident when the parties, in addition to the SPA, likewise entered into an assignment of membership interest in Chevron Malampaya LLC, whereby Chevron, as the assigner, agreed to assign, transfer, set over, deliver, and convey to the assignee, UC Malampaya, all of its ownership interest in the company. Among such interests includes that in SC38. So the first paragraph is very clear. Inasmuch as the SPA involves transfer of interest SC38, the same must be approved by the DOE before it becomes binding and effective. So this was a document sent by the DOE to us, and we had to call through numerous documents. No? And again, this is consistent with the email that you sent us. This is consistent with ASEC Polido's statement. All of the personalities in DOE, including the legal team, this is from the legal, had the same opinion that it has to go through review and therefore after approved by the DOE. So this is where the confusion is coming in, Secretary, because now you're saying that it doesn't need review. But it went through, but your team is saying it needs review.
Yes, and all of this confusion, of course, Mr. Chairman, is also because on the different interpretation of the assignments of interest, and therefore the saying is that farm-in, yes, it does require prior approval, but on the sale of on the share sale, that is something that I believe that we need to clarify, and a remedial action here for the future is a clearer legislation and for DOE to also make the necessary adjustment, Mr. Chairman.
Mr. Chairman.
Yes, Senator Risa, go ahead.
Salamat, Mr. Chairman. I think it's possible, Mr. Chairman, na bukod sa confusion, which is the term that the chairman very kindly and graciously uses, baka kasi parang lumilinaw na sa isip ko or isip natin, baka naman malinaw na rin sa isip ni Sec. Cusi. It is, I would guess, I'm just guessing, Mr. Chairman, hindi po ito confusion. Ito po ay debate or push and pull kung aling interpretasyon ang mananalo. Kasi, I mean, bakit pa may legal services ang anumang departamento except that it has very good and trusted lawyers and other legal advisors to advise the Secretary on the legal aspects of any matter, including this. So, I think, well, Mr. Chairman, yung keen interest and value that I place dun sa paalala ni Chairman, yung pinakita ninyo na email at yung pinakita pa ninyo nitong pangalawang dokumento, it is of very current value, Mr. Chairman. Hindi lang ito pang moving forward for future legislation as the good secretary suggests. I think kung ngayon pa lang may nakita tayo from the input of the department itself, legal services, kung mayroong mali o kulang na proseso na ginagawa, then I maintain my thinking aloud, Mr. Chairman, of a policy question na baka pwedeng isuspend muna iyang process na iyan because perhaps it will be proven sooner than later, Mr. Chairman, na kung meron tayong ganung rekomendasyon, we can prevent a harm being done to the national interest because hindi lang po ito tungkol sa kahit anumang kontrata o kumpanya o natural resource. This is malampaya, Mr. Chairman. Isa sa crown jewels ng ating energy resources, which are the main thing that the DOE is taking care of or should be taking care of, Mr. Chairman.
Mr. Chairman?
Yes, Secretary, you may respond.
Thank you, Mr. Chairman. That's why, because of that there is no clear rule on the farm-in, on the share sale, which was, as I've said, been done before. Hindi naman kailangan ng approval ng DOE. So, we could have already say, wala kaming ginawang, hindi na namin kailangang i-review or approve that, no? But based on the previous practices. But what we did, we still reviewed, no? And parang in-apply pa rin namin yung parang pag-farm-in rules dito sa share sale na ito. And sabi nga nun that I hear that when people were explaining, sinasabi nga na hindi na namin sana kailangang review, but we reviewed it para talagang to go through the process and protect the interests of the Republic. And they used the criteria on the legal, technical, and financial. So on the legal, pasado. Sa technical, pasado. Sa financial, pasado. Nagbayad. Can they carry out the work? They said that they carry out the work. Is that further drilling? Kaya naman po. So, and they are not the only one funding it. So, natuloy itong ito. We gave that approval on this sale of Chevron and Udena. But yun dun po sa Shell, sabi ko nga po, that is different. That will require prior approval of the DOE because it's clearly stated in the contract. So dito po, dito sa Chevron, parang na-review na ng DOE, legally pumasa, technically pumasa, and financially pumasa, kaya na consummated na po yung sale nito. Ngayon, sinasabi rin po, kasi para sabi ko nga po, maliwanag lang, hindi naman po ang gobyerno ang nagbenta nito. And we are also looking at the risk, and we have been discussing that pababa din po ang reserve ng nitong Kalampaya, and this will further be depleted kung hindi po ito malalagyan ng immediate action, and that is the drilling that we have required for them to conduct. Itong sa consortium po, hindi lang po dito sa Udena. Sa consortium po must do it. And they have submitted their work program. Yun lang po, Mr. Chairman.
Well, Secretary, I actually I'll share another document now because Senator Risa was correct in saying that I am using a gracious word or a gracious description because I want to be as cordial as possible. No, but in the same email, it's actually very clear, no, to the DOE. If you read the title, Study in Clarificatory Circular on the issues that have arisen relative to the sale and purchase of interest. We're talking about the Chevron deal. In the first paragraph, DOE, galing to sa inyo ha, DOE believes that the pertinent provisions of the DOE Circular, DC 2007, are clear in itself and does not require further clarification in connection with the sale and transfer of interest in a petroleum service contract. And then the second paragraph actually goes on. No? And let me just read it so that it will be on record. As provided under Section 11 of PD 87, the governing law, rights and obligations under a petroleum service contract shall not be assigned or transferred without the prior approval of then Petroleum Board, now the Department of Energy. To implement the foregoing, the DOE promulgated Department Circular 2007, prescribing the guidelines and procedures for the transfer of rights and obligation in petroleum service contracts to ensure that the assignee or transferee possesses the requisite legal qualification, financial resources, and technical expertise, experience to undertake the obligations and commitment under such petroleum service contract. So here, they said it's clear that the DC 2007, which is derived from PD 87, is applicable to this transaction because ang question is relative to the sale and purchase of interest. So it's very clear. And it's important to note that the guiding law is PD 87 and DC 2007. That is what the DOE used. And in the reason why I wanted to point that out, because Secretary, what you have approved is a very powerful, it's a very powerful document. No? And let me just show the approval letter that you issued. No? And this is no ordinary approval because like what Senator Risa said, this is malampaya. This approval will radically change the dynamics of how Malampaya will be operated and the future wells around Malampaya. So this is the approval letter that you issued. Let me just remove the ano kasi it's confusing. And in the approval letter that you issued to specs, no? This is to Mr. Don Paulino. This is in accordance with Department Circular 2007, entitled Prescribing the Guidelines and Procedures for the Transfer of Rights and Obligations in Petroleum Service Contracts under Presidential Decree 87 as amended. We have to take note that you use PD 87 and DC 2007. After thorough review and evaluation of the submitted documents of SE 38, the acquisition of 45% participating interest in UC 38 LLC under Service Contract 38 was found acceptable and is hereby approved. So na-approve po using PD 87 and DC 2007, which your legal department from day one said should be used for the sale of interest in SC 38. So in other words, consistent ho, from the time we had our hearing in November, from the time your legal department issued that legal memo, and from the time you approved it, you consistently used PD 87, DC 2007, because in the eyes of your legal department and in the eyes of DOE, this transaction needs to be approved using PD 87 and DC 2007. And hence, you approved it.
Tama po yun, tama po yun, Mr. Chairman, that I approve it. And that's why, as we have been saying since the very beginning, that in view of non-clarity of rules that will be implemented on the sale of shares and the farm-in, we use the farm-in rules to protect the interest of the country. Ginamit pa rin natin po yun. Kaya nga po dumaan po sa legal, technical, and financial. So, kaya yung po sinasabi namin na sa base po do sa mga nakaraan na transfer ng shares ng ibang kumpanya to SPECs, ang nangyari po dito, sinunod namin po yung rules ng farm-in. And we said that yes, kasama po yung approval ng technical, legal, and financial. So pumasa naman po, and that's why we issued this approval. Otherwise, kung hindi po nagpasa yan based on the evaluation, hindi po naman siguro i-recommenda ng mga tao na that it be approved, Mr. Chairman.
Mr. Chairman?
Yes, Senator Risa.
Yes. Salamat, Mr. Chair. Did I miss something here? Kanina po paulit-ulit na sinasabi ninyo, Sec, na hindi na kailangang aprubahan ng department ito. Ngayon, sinasabi nyo na kailangan ngang aprubahan at inyong inaprubahan. So, which is which, Mr. Chairman, Secretary?
Yes, kaya nga po, Mr. Chairman, if I may, no? Base po sa pang-usap-usap sa discussion itong ng sale ng pool na ito, no? Po ninyo yung process flow kung paano nangyari. Ang sinasabi nga po, base doon sa mga previous practices, hindi na po dapat pumasa doon sa farm-in process ng approval po. And that is prior approval of DOE. So kaya po natagalan ito eh. Natagalan po ang approval nito dahil kung ano paano i-evaluate. And our RDB po at saka yung legal came out with their evaluation using yung proseso ng farm-in. Yun na rin po ang inadapt nila. Kaya nga po sabi ng gano'n, kaya naaprubahan po yan eh. Excuse me, nagtatalo po nga po doon sa financial and legal. It's evaluated by financial, legal, and technical. Pumasa na po. So sinasabi, whether it is the rules of farm-in or not ang gagamitin, pumasa po siya doon sa rule ng farm-in. So napasok po ang approval na yan. And that is the reason why it has been recommended to me and I have approved it and issued that approval that you correctly showed, Mr. Chairman.
But Secretary, nowhere in the documents that the DOE submitted to us, that argument of using the farm-in and that argument of this should not be evaluated, however, because of energy security and all of that, it should be evaluated using farm-in. From day one, we were made to understand that this should be approved by the government. And the process should follow PD 87 and DC 2007. So from day one, it was very clear. Now, nowhere in the document that you submitted that stated that you use the farm-in procedures, which is another procedure, but the procedure was clearly outlined through PD 87 and 2007. So that's where, again, no, I'm not that's where I'm not following because initially you mentioned that this is not supposed to be government approved. The government should not review and approve it, but then again you approved it. But then you're saying that you use a different method. But when I reviewed the documents, there's no such disclaimer that you use a different method. So all along in our mind, this went through the normal process of DC 2007.
That's true, Mr. Chairman. To play it safe, we to be on the safe side, we used that evaluation. We used the farm-in. We used that the rules when we even were thinking and discussing that it should not be. So to play on the safe side, Mr. Chairman, yun po ang sinunod namin. And that is the reason why I issued that approval. So hindi rin po ito is it's not something that hindi na kailangan approve na yan. No, we did a lot of discussions, a lot of evaluations were done. And kaya nga po sabi ko, on the safe side, we played safe. Kaya ginamit na rin po namin yung sistema ng pag-evaluate. Yun po ang nangyari, Mr. Chairman. So if there will have caused confusion,
Yes,
for apologies.
Thank you, Mr. Chairman. Well, no apologies necessary, I guess, Mr. Chairman, kasi kaya nga tayo nag-budget hearing to be very clear, not confused at all about this whole budget and its implications, especially for very important issues like itong Malampaya. Sabi po ninyo, Sec, na you tried to play very safe, but kung ano man po yung prosesong dinaanan nyo, yung sinasabi nga ni Chair na mismong ang legal nyo sinabing dapat daanan yung sa PD 87 at sa DC 2007 or itong bagong sinabi nyong farm-in agreement, still, you have come to a decision, the department has come to a decision na baka nga hindi safe para sa ating bansa. Baka it places our country in danger, not of danger, Mr. Chairman, not in terms of attack, but in terms of being put at a disadvantage. Kasi nga, gaya ng binanggit ko kanina, itong Malampaya, isa sa pinaka, mahalagang hiyas ng ating bansa. It could even be asked, for example, Mr. Chairman, if later on, more gas and oil are found in the West Philippine Sea, pwede ba yung i-link sa Malampaya pipeline? So we're not only talking about the Malampaya reserves themselves, pero yung pipeline, which initially ay daluyan nung reserves na nasa Malampaya, or which may later on be found in other parts of the West Philippine Sea. May isang ulat po kasi na nabalitaan namin, Mr. Chair, halimbawa na in fact, Malampaya will be used to pipe the gas that might be discovered in other wells in the West Philippine Sea to pipe it, say, to Batangas. So ganyan ka importante, strategic over a long geographical distance. And kanina po, Mr. Chair, nung nakikinig ako sa sinasabi ni Sec, were you saying, Good Secretary, na ang UDENA ang mag-finance ng energy exploration kapalit ng share nila, Chevron share sa Malampaya? Kung ganun po ang isang scenario, paano i-finance yun ng UDENA? So, with all these difficulties that UDENA is going through, that the DOE seems to be going through over this very rich Chevron subsidiary, mayaman kasi nasa kamay niya yung jewel na yan na Malampaya, it just means that it's not a resource that is actually depleting, full stop. It may be under pressure now dahil ginagamit natin, pero baka it has not just long-term but also short-term, immediate na additional resources attached to it. Hindi siya magde-depreciate, baka mag-a-appreciate siya. At kaya rin, napaka-importante sa komite namin itanong ito during this budget hearing, Mr. Chairman.
Thank you for that, Senator Risa. Definitely, because this might not pertain directly to the budget, but these are policy questions that will affect all of us, and this is an opportunity for us to ask those policy questions. So, I just going by the evaluation, Secretary, because you mentioned na pumasa itong UDENA o pumasa the entity went through a thorough, rigorous evaluation. But we also noticed something in the evaluation, the entities that were evaluated, legal, technical, and financial, were not the same. Just as ignore the 1P and OCEC. But in the DOE side, for legal, it evaluated UC Malampaya. For technical, it evaluated UC Malampaya. But for financial, it evaluated UC 38. So, sino ba ho talaga ang ini-evaluate? Because, like I said, it was given a stamp of approval. But if you look at the entity being evaluated, nag-chapsuy ho siya. So I want to ask, which one talaga ba ho ang ini-evaluate ng DOE? Again, these are documents you submitted to us. We just painstakingly made sense out of it. And personally, I personally read it twice, even more. But this is what I gathered also. So how come the evaluation of DOE had different entities,
Yes. Thank you, Mr. Chairman. PNOCEC is looking at who will be their partner, whether they can continue with their work. While we are evaluating on the finance, is the UC38, tama po yun, because who will carry out the work program. It is not just UDENA, it is not just PNOCEC, it's not just Shell, but it is the consortium. So we are looking at the UC38 capability. Kanina po sinabi rin po ni Senator Risa about the financing na maybe na misunderstood po, na partly na hindi po hindi lang po UDENA ang mag-finance niyan. May contribution po sila. So the total work po nito ng work program, ang ini-evaluate po natin is that the continuity, tama po yung sinasabi ni Senator Risa, na kailangan magawa talaga yung mga trabaho na yan. So UC38 po ang tinitingnan natin. Yung po sa financial evaluation, kasi sila po yung consortium na yan, ang tinitingnan kung hindi lang po isa ang tinitingnan natin, hindi lang po isa, but yung the full consortium to carry out the work. That's why when we meet with them, when we met about the work program, we meet with the consortium, not the individual members. No po, na ganun ang nangyari. And then, so, totoo yun. Ito sa dokumento nito, the DOE evaluated the UC38. Yan po ang puno natin yan. And then, dito po naman sa structure, yung sinasabi kanina po, papaliwanag ko na rin po. Yung sa structure po, by 2024, when the term expires, no po, the structure po will revert to the government. It will be owned now by the government, no? That's why kung magkakaroon po ng extension, we are looking at seeing paano gagamitin itong structure nito, which is owned already by the government. So kung magkakaroon po ng linkage, kunyari po magkakaroon ng discovery question, can we use that? Well, the government owns it and we can allow to use it depending on the terms and conditions. So yun po ang tinitingnan natin. So going back to this thing, the UC38, para sa continuity of the work, tinitingnan po dito yung buo, yung UC38 ng DOE. Hindi lang po yung isa. Hindi lang po yung isa. Yun po ang ginawang evaluation ng DOE po. At ang UC38 is Efron Malampaya. Ganun po ang kanya.
But Secretary, in an evaluation, we have to be consistent. If we're evaluating UC Malampaya legally, then we have to evaluate it also financially, and we have to evaluate it also technically, or else it will be uneven. Who are we? In short, we're evaluating different entities, and then we're approving also different entities. We have to be consistent on who are we evaluating, because that's the entity we are approving. So that's another inconsistency that we saw in terms of the evaluation of the department. Ibang entities po ang in-evaluate.
Well, Mr. Chairman, ang kadil po rito ng DOE, ng gobyerno po, is the consortium, not just Chevron. So we are looking, our interest is to make sure that the work by the consortium will be carried out, it will be delivered, and yun po ang sinigurado. Ngayon po, yung pagpasok po ng UDENA sa Chevron, ang sinasabi nga po rito is this is a share purchase po. Binili po nila yung shares. The corporation, Chevron, remain the same with the consortium. So lahat po ng libro niya, lahat po, everything, his assets and liabilities remain the same. Hindi po nagbago yun. Walang pagbabago. Ang nagbago lang po doon is yung sino ba may-ari ng shares of the stocks na yun. So the personality of Chevron that we are evaluating, PNOC and Shell, pare-pareho po yun. No po? Sabi nga natin dito, anong daladala ng UDENA pa rito? We went beyond. No po? We went beyond that. Sabi, meron pa silang mga 30 million or so na pwede rin ipasok. And that is plus to the Chevron that is already there. So, yun po naging process ng evaluation. That's why sabi nga natin dito, ano po ba ang gagawin natin in the future? Sabi, okay, siguro talaga kailangan natin magawa ng adjustment on the basis of this discussion that we are having still, Mr. Chairman.
Secretary, ang problema ho kasi there's already an approval no? And there's a lot of questions on the process. And in fact, if I showed you the evaluation process, different entities were evaluated, and then even though different entities were evaluated, it was given a stamp of approval. So parang I cannot comprehend how we can come up with a evaluation of different entities and approve the transaction by UC Malampaya.
Well,
And there, again,
Chair.
I'm trying to, all of these documents, Secretary, came from your department, and I thank you. I thank you for furnishing us all of these the documents. We just really made sense out of it. And we find it's consistent, then well and good. That's what we want. We don't want to have this kind of discussion. But the thing is, we found a lot of inconsistency. So the problem is, in my opinion, the approval is definitely defective because of all of this inconsistent evaluation.
Well, Mr. Chairman, if we see defects in the on the evaluation, the result, we would not have approved it. That's for sure. But ang sinasabi nga lang po natin dito is that yung pong pag-evaluate, why UC 38 ang in-evaluate at hindi po yung UDENA? Bakit po ganon? Because ang nakadeal po sa gobyerno is the UC 38 po. Hindi po naman yung UDENA. Po, hindi po UDENA. Kasi if you look at the circle, you have the Chevron, SPECS, and then you have the PNOC-EC. We are not dealing with them one by one, but what we are dealing is the consortium. So what evaluating is the consortium to carry out the work. One of them might falter along the line, but the consortium that we are looking at must carry out the work. So pagpasok po, kaya nga po sinasabi namin dito, kaya sabi nga namin dito is this a share purchase agreement? If this is a share purchase, then the company does not change. It's just like I bought a share, the company remained the same. All asset and liability, nandun. Pare-pareho pa rin. Hindi po naman yung UDENA company ang pumasok, ang nagpalit dito sa Chevron. Kasi shares lang po binili. Naiwan pa rin po yung company. Sila pa rin po yung nakadeal dyan. So we are looking at the three as one. Para sa pagganun po, maki-carry out yung trabaho, yung sa performance sila. So, kaya nga po siguro, sabihin lang natin na, kung ganun pala, kaganon, yung pati amendment ng corporation law, kailangan nating gawa para we can review it, we can have a better, yung better evaluation kung paano.
But Secretary, that's my point. Nowhere in the documents you submitted elaborated your explanation now. Wala ho yun. That's what you explained right now. It's none in the documents you submitted. That's why we're made to understand that PD87 is going to be used, DC 2007 is going to be used, and the transaction will be evaluated. And what is the transaction? The transaction is UC Malampaya buying the shares of Chevron Malampaya. That is the transaction. So that's why in the beginning UC 38 wasn't a personality. Wasn't a personality. That's why in this evaluation, it's consistent. The legal evaluated UC Malampaya because siya yung bumili. The technical UC Malampaya. Bakit biglang sa financial, iba na? We have to remember, we have to keep in mind, the transaction is between UC Malampaya and Chevron. Yun ang transaction. We have to evaluate that transaction. We're not evaluating the existing operators. Because from the beginning, in the documents that you submitted, the transaction needs to be evaluated. And what is the transaction? The transaction is between UC Malampaya and Chevron. That's why yung legal department nyo, tama dito, consistent siya eh. The financial lang ang nag-iba. And during our hearing, this was not answered properly, yung financial evaluation. That's why I'm asking you straight, because you're the one who approved it, so that we will be enlightened. What is the logic?
Well, put it this way, Mr. Chairman. When Chevron offered this for sale and they invited buyers, they evaluated their buyers. And finally, they made the decision of selling it to Udena. So that's how it was. So they evaluated the financial capabilities of Udena. So they sold their shares to Udena. So now, what are we going to evaluate except SC38? I mean, except what do you call this? The Chevron as a corporation, a member of the consortium. Did it change the financial capability of Chevron? Did it change the legal personality of Chevron? Was the sale illegal? Did it risk the technical capability? And wala naman pong nangyaring gano'n. Kaya nga sinasabi namin na, ano ba itong sale na ito? Iba po yung farming eh. Kung nag-farming talagang tanggal ka dyan, yung kumpanya ko ang papasok po. Yun ang sinasabi namin farming. Eh kaya lang ito, share lang yung binili ng itong mga tao. So pumapasok po sila. The corporation that is that we are dealing with is the same. It's the consortium. Kaya tinignan namin, the entire consortium, will it be at risk? Okay. So, legally, technically, walang pagbabago. So, kinuna po natin, sa financially, nandun pa rin po naman, anong kakanin natin? I-questionin po namin ang capability ni how Udena bought Chevron. How did they get the money? How did they go? I mean, how they were paid? At what price? Hindi na po namin alam yun eh.
Secretary, I was asking myself, bakit sa financial, it was UC38 that was evaluated? Because I want to understand also where the department is coming from. And this is a document came from your financial services department. Ito yung evaluation nila. And again, I thank you for sharing this with us. This document came from you and from your office. And this is what we saw. No? UC Malampaya has negative working capital, while UC 38 has 177 million. UC Malampaya, in effect, is Udena. No? Is in Udena.
Yeah.
So, this is what your financial services saw, and that's why it made me. You cannot blame me for thinking that the reason why UC38 was the one evaluated because it's the one healthy, financially healthy. UC Malampaya obviously is not healthy.
No, sir.
So that's why that's my thought, because I was asking bakit consistent financial technique biglang sa financial iba.
We evaluated also the Chevron because the company that dealing with the consortium is Chevron. Hindi po nagbago yun. Kahit na po pumasok ang Udena. Ang Udena can be without money, negative, whatever. Sila lang ang pumasok dito, sila po may hawak kayo ng certificate. Ito, binili ko na po itong certificate ng Chevron. And whatever recurring revenue that will come from Chevron will be mine. And whatever liability, I will pay. So, ganun po yung naging Hindi po nagbago yung personality, yung libro ng Chevron. Siya pa rin ang membro. Hindi naman po nangyari nga. Siya sinasabi ko na yung Chevron nawala, nagdala-dala nila lahat, at ang Udena ang pumasok. Nasasabihin natin na, oy, negative yan eh. Pumalit, negative. Hindi naman po pinalitan yung Chevron eh. Yung Chevron pa rin doon. Kung ano ang financial capacity niya, kung magkano ang bank balances niya, yun pa rin po yun eh. Hindi naman po tinanggal natin yung Chevron, pumasok yung Udena. Pagka ganun ang deal, iba po yun. Yun ang sinasabi natin, nababagsak sa farm-in po yun. Nasasabihin natin, wala kang kwarta, papasok ka. Ito, Chevron, ipasok po. So talaga pong, maybe we are just in, I know that we are both trying to be protective of the interests of the country. And we are just both following what the laws are there. So, ang kaya sinasabi ko nga po, kung ganun, lahat na lang ng treatment natin, farm-in. Para sa ganun, palit ng personality, palit ng kumpanya, bunot ito babaguhin natin. Pagka farming po, ayan. Wala po tayong problema. Anyway, doon naman sa sale po ng Shell, maliwanag na maliwanag, prior approval. Ginawa na po nilang condition yun para wala na pong issue. Ganon.
Reason why we're raising this, kami ni Senator Risa, because there's a Shell portion pa. No? If this is exactly the same method that it will be used, I guarantee you, approve na rin. So, and that's why we're flagging this because, in my opinion, the approval is defective because the methodology is defective. But the repercussion is quite tremendous because it's an approval of the 45% stake and interest in SC38, which is Malampaya. So, Senator Risa?
Salamat, Chair. I was just going to add na dahil maya't maya binabanggit ninyo, Sec, yung farm-in agreement, naghanap na rin ako, ano bang legal definition yan? Kasi kanina po, Chair, habang nakikinig ako rin, I'm the kind of person na kapag mas simple at straightforward, consistent yung pag-describe sa isang proseso, mas nagmumukha talaga siyang maayos and alam nyo, by the book, yung diretso lang. So, I kept hearing farm-in agreement. So, alam nyo, Chair, may nahanap akong isang legal definition no, na farm-in agreement means an agreement whereby a person agrees, among other things, to pay all or a share of the drilling, completion, or other expenses of one or more wells, or perform the drilling, completion, or other operation on such well or wells as all or a part of the consideration provided in exchange for an ownership interest in an oil and gas property. So, kahit po yung bagong terminong ginagamit na farm-in agreement, meron talagang kinalaman sa financial capacity. Kaya talagang makakatawag pansin na after evaluating one entity on the legal and the technical, kung bakit nga ibang entity naman ang in-evaluate sa financial. So just an additional food for thought that caught my eye, Mr. Chairman. Salamat po.
Thank you for that definition. In fact, this is the first time I've heard of that farm-in method. In our third hearing, I think Senator Risa was also there. The justification that was used by Attorney De La Fuente was benchmark. It's a benchmark review, which again, nowhere in the documents that were submitted to us made mention of benchmark. No? So again, these are we don't have any documents other than the ones you submitted. We're just trying to make sense out of it. No, I was hoping to see some consistency so that we don't reach this point. No? In any case,
Mr. Chairman.
yes, go ahead, Secretary.
I know that you asked me to be the one to present and answer all, but with your indulgence, I think it would be best if we allow ASEC JERP to discuss the the slide on the screen, if you will allow, Mr. Chair.
Yes, we recognize ASEC JERP.
And I will take a bladder break, Mr. Chairman.
Thank you very much, Mr. Chair. Thank you very much, Mr. Secretary. We just present to you a graph of figure or presentation or representation of what transpired through this presentation, Mr. Chair. So we have here the Malampaya project, composed of 3 members of the consortium, Chevron Malampaya, and OCEC in Shell Philippines. Next, these are owned by mother companies, Chevron Philippines, Bermuda, for Chevron Malampaya, and Shell Netherlands, or NV, for Shell Philippines. So these are the mother companies. Next. So what happened was the share of Chevron Philippines was sold to UC Malampaya, and the share of Shell Netherlands was sold to Malampaya Energy Exploration. Next. Still, we have Chevron Malampaya and we have Chevron Philippines. They did not change. They're still the members of the consortium. But now there we have UC Malampaya and Malampaya Energy in the drawing because they now own the shares. But you see that the corporations that are members of the Malampaya project are still the same. Chevron Malampaya, OCEC, and Shell Philippines. Then we see going down from Chevron Malampaya, it became UC38. Why? Because of the trade name of Chevron, they want Chevron to be taken out. That's the reason why there is a change of name. And eventually, we do not know what will happen in the final evaluation. Shell most likely will also ask that its name be taken out of the corporation because it is its trade name. But you see, until that point, there was never a change in the personality of the corporation that are members of the consortium until now. So, Mr. Chair, the financial capacity of Chevron Malampaya is the financial capacity that it has from the very start. The Chevron and Shell Philippines were the ones that were evaluated from the very start as technically and financially capable. Sila hindi nagbago, and they came out of the project. They earned $468 billion given to the government. These are the companies until now that giving to the government. And until 2024, that will still be the companies that will be involved in this project. And the financial capacity, of course, of the project that is running the show should be the one that will be taken into consideration. Does it have the financial capacity? Can it run the project? Can it finish the project? So, Mr. Chair, as you see, this is still the setup right now. Nothing's changed. The corporations that are running the show, that will complete the project, are still the corporations. So we don't have to be afraid of anything because these are the same corporations that are technically, financially capable. And they have the liquidity. They're earning yearly. Thank you very much, Mr.
Secretary P, we're not afraid of UC Malampaya. What we're afraid of is government not following its own rules and customizing the rules to favor an entity. That's what we're afraid of. What we're afraid of is there are set rules that you promulgated, DOE, but you're also not following it because an entity is being favored. That's what we're afraid of. That's why we have rules and we have that circular that you want to, that we follow. And this is where I don't understand it. Again, this came from you. I'll show you a slide.
Yes, Mr.
These are the approvals. No, these are the approvals that you made. Okay. These are the approvals. If you look at the financial, number 39. in a memorandum dated 2nd of February, FS found UC38 be financially qualified to acquire the 45% participating interest. Sa baba. And then the legal evaluation in a memorandum dated 23 November 2020, legal services found UC Malampaya to be legally qualified to acquire the 45% participating interest in Chevron Malampaya in SC38. Technical evaluation in a memorandum dated 19 November 2020, PRDD found UC Malampaya to be technically qualified to acquire 45% participating interest in Chevron Malampaya. So nakita nyo, you evaluated UC 38, financial, and then legal, you evaluated UC Malampaya, technically UC Malampaya. But this is the clincher. So we recommend approval of the transfer of participating interest since it is a non-operating interest with no substantial effect in fulfilling the work commitment under contract. Notably, after the purchase of UC Malampaya of the shares of Chevron Malampaya, and the latter renamed UC38 LLC. So you recommended it. So iba-iba eh. This is where we're pointing out the defects. No? Because if you want to evaluate, you only evaluate one entity to be fair. You don't
Mr.
evaluate
Chair,
different entities and say they're all qualified. We have to be very clear who are we evaluating.
Mr. Chair, can I answer that?
Yes.
Yes, Mr. Chair, precisely that is where the confusion came from. Because in the desire of the Department of Energy to see to it that we protect the policy of energy security, we came out with that benchmark. And in that desire to apply that benchmark, that DC, it speaks of two corporations. The seller selling its rights and obligations, and the buyer getting the rights and obligations of the other corporation. Precisely, when you apply that DC, you're talking of two corporations. And when it went to the legal team, it evaluated one corporation. Then the technical, it also evaluated one corporation. But when you go now to the financial obligation, Mr. Chair, you will only evaluate the corporation that will run the show, that will complete the project, that will remain as part of the consortium. I think that's where the confusion came from. That's why the legal team came out with its evaluation naming UC38 because it is UC38 that is running the show. Now, Mr. Chair, in the course of all these inquiries, we really found out that there was really a confusion on the evaluation that was done, because with respect to the DC, it speaks of two corporations, when as a matter of fact, in a share sale agreement or transaction, there's only one corporation. That's only the corporation that has the shares. It never changed. So what we are doing now, Mr. Chair, so far as DO is concerned, we went to the drawing board. We went to the drawing board because we have to adjust. We have to see to it where the confusion came from, and we must be very, very clear about it. That is why, if you could remember, Mr. Chair, in the last hearing, I mentioned about remedial legislation, because if the Honorable Committee sees that there's some things to be clarified, then let's do that. Speed 87 has been there since the 1970s. I think it's high time that we should clarify or make changes to this law. But it's a law signed by President Marcos and still here. And now we're still discussing about it on some confusion. We will make some remedial legislation, make things very clear. And on our part, on the Department of Energy, Mr. Chair, we have now started going back to the drawing board and seeing how we could improve, how could we be more precise and exact so that we won't have any confusion like this again. Thank you, Mr. Chair.
ASEC, we've been earlier, Senator Risa and I, we've been questioning Secretary Cusi. Nowhere in his answers came out the words benchmark. It's the first time I heard it this time around. What he used earlier is farm in. We use farm in. That's another confusion that you are creating. Ano ba talaga? Is it farm in? Is it benchmark? That's number one. Obviously, trying to salvage something. No, you're trying to salvage this this transaction. Second, this is the worst. ASEC, you approve the transaction. The transaction has already been approved. And this is no ordinary transaction. It's 25 billion pesos in terms of purchase price. It powers 30% of our requirement. That's around 4 million homes. There should be no confusion in the approval. This is not an ordinary approval. Like we said, that's why even last year, Senator Risa and I we were together in that hearing. We were saying, this is no ordinary asset. We have to make sure that it's clear and there's no room for doubt, especially political doubt. Because you cannot erase that from our heads kung may confusion. So, but it's already been approved. And in my opinion, it's a defective approval and an invalid approval. Because all of these things, may confusion eh. So in any case, Senator Risa?
Mr. Chair, I would just like to concur with the opinion of the chair that because it is a defective approval, that we consider it an invalid approval. Speaking of going back to the drawing board, perhaps our country through the DOE should really go back to the drawing board on this approved contract. It even seems, Mr. Chairman, from the presentation of the chair of this memorandum to the secretary, parang nagkaroon ng compartmentalization within the department itself. Legal took care of one evaluation, other parts of the department took care of other evaluations, to the point that, ayun, as the chair has shown, one of the evaluations refers to UC 38, while the couple referred to UC Malampaya. So again, it doesn't lend itself to inspiring confidence dun sa mga pwedeng tumingin sa mga documents that are underlying this transaction, Mr. Chairman.
Thank you. Yes, ASEC, go ahead.
Yeah, the word farm in, Mr. Chair, we just tried to summarize that PD 87 and that this 207. It's not another term, Mr. Chair. The PD 87, when you buy and transfer rights and obligations like service contract, goes to the other corporation, that's farm in. It's just a term that we use, but it is actually referring to that provision in PD 87 and with the Department Circular 2007, Mr. Chair. And let me just explain, Mr. Chair, there's no confusion in the evaluation. Ang nangyari lang dito kasi, because of the DC, parang ganito yan, may nakita kang dalawang tao sa daan, di ba? So, ang sinulat mo doon, yung nakita mo na isang tao, hindi mo dinescribe na mabuti yung isang tao. Something like that. That's what you highlighted. So, you just describe something, but there's no confusion. The end result is, alam mo na, walang problema dun sa kinalalagyan nila, tinatatayuan nila. Na-highlight mo lang isang tao because yan nakita mo. And that's what happened here. Na-highlight yung isang corporation, but the capability is one and the same. Bago yan. At sinasabi ko, na-emphasize ko, dito sa financial capability, walang problema kasi dito, klarong-klaro, na the one who's going to implement the project is the member of the consortium. So, yun talaga ho ang lumabas evaluation ng financial team po namin. Yun talaga. Kasi una, I want to emphasize yung isa na lang, Mr. Chair, yung energy security natin, itong project na ito, hanggang 2024 lang naman eh. And we know very well, Mr. Chair, nakaproject na yan eh. Hindi naman nakaproject na yan, work program, yung financial matters, things that they're going to spend. Nandun na yan hanggang 2024. So I don't see where the problem is. And the extension is another issue, of course, because a lot of things are going to be evaluated. But when we talk of energy security, we found out that until 2024, which is the timeline of the project, buhay pa tayo, no problem. Thank you very much, Mr. Chair. That's all.
Sec, I think we've already shown enough, no, in terms of our conclusion to this transaction. And again, my opinion of this is a defective approval. Therefore, the approval is invalid because clearly, there's a lot of inconsistency, and major transaction like this should not lead to confusion. Instead, it led to a lot of confusion. Instead of appreciating it, we got more confused. And by your admission also that there is confusion, and you have to go back to your drawing board. So, in any case, this is a budget hearing. We just propounded some policy issues so that the department will be flagged and reminded, especially with the ongoing review of the specs, the shell exploration side, because there's also a pending transaction with that side. But we will be very vigilant in terms of how you will be evaluating and approving that. And we will definitely conduct the same very thorough due diligence in order to protect the interests of the Filipino people. So with that, Senator Risa, any more questions to the DOE?
Mr. Chairman, i-reserve ko na lang po sa susunod na hearing, which the chair earlier told Sen Coco that you will be scheduling. But I will send my remaining questions ahead in writing sa DOE para mapaghandaan na po. And then also request a few clarificatory documents from them bago yung susunod na hearing natin. Salamat, Mr. Chair. Salamat, Secretary.
Thank you.
Thank you, Senator Risa. So, with the request of Senator Risa and Senator Pimentel, we'll defer the approval of the budget of the DOE. We will confer as to when we can have that next hearing. We will ask the Secretary for his available time, and of course, Senator Risa and Senator Pimentel. So with that, we will defer the budget of the DOE for now, and we will move on to the budget of the ERC. But I understand. Oh, okay, yeah, all right. No, Senator Bong Revilla is waiting for his turn. Actually, he has some questions for ERC, but we'll pursue with the budget of ERC. Again, the budget is not as big, relative to the other departments, but nevertheless, it's a very important entity in the electric power industry. So we recognize, thank you very much, Secretary Cusi, for your participation, and thank you very much for staying with us until this late in the afternoon.
May I say something, Mr. Chairman?
Yes, go ahead po. Go ahead.
Thank you, Mr. Chairman. We spent a long hour here today, but very productive, I believe. And we respect your opinion. You respect your position regarding the sale of Malampaya. But I just want also to reinstate that the DOE did what it could do to protect the interest of the Republic. And it has gone beyond. And of course, in this process, nadala na rin po kami sa korte. And well, sabi nga po namin, that's the hazard of the trade. And we have to face that. But I'd like to thank you for this afternoon's meeting, and I assure you that well, we did not do shortcuts. That's why there are many issues, many factors that are being considered. You have farming and all those things, and having it benchmark and the laws, the legal people. So we did, we did not do any shortcut in this thing. We did not compromise anything here, and the only interest is really the interest of the Republic and the Malampaya. Thank you, Mr. Chairman. And if I may be, if I can be excused already,
Yes.
because I have another meeting at 6, Mr. Chairman.
Yes, sir. I know we've taken a lot of your time.
Wait, I have here, Mr. Chairman, the renewable, the updates. I just send it to you immediately today.
Yes, please, Secretary.
Thank you, Mr. Chairman.
Thank you.
Thank you, everybody. Thank you, Senator Riza. Thank you, colleagues in government.
Salamat po, Chair.
Thank you. Now we recognize Chairperson Agnes de Banadera.
Thank you very much, Mr. Chairman, Your Honors. Good afternoon. We would like to present the budget of ERC, of the Energy Regulatory Commission. And we would like, may we go straight to, in the interest of time, Your Honors, may we go straight to the ERC accomplishments for 2020. For, as shown on our slide, the number of approved certificates of compliance or the provisional authority to operate for the year 2020 is amount to 201 generation facilities. That's a total a number that we have covered with our COCs and POWs, with a total capacity of 10,537.84 megawatts. And 10,000, sorry. The next one, Your Honors, is that we have approved a total of 6 applications for 2020 for the point-to-point, with a total project cost of 741,732 and 807 pesos. For the CapEx applications, Your Honor, Your Honors, we have approved a total of 29, and with a total amount of 6,547,440,752. For the power supply agreement, we have provisionally and made one final approval for 13 PSAs, and they amount to 45,053,852, Your Honor. And continuing with the 2020 accomplishments, we started to implement the rules for interim reliability performance indices, and these rules actually, for the first time, have set the maximum allowable unplanned outage number of days per year. And this means all generating units may not go on outages beyond the provided maximum cap per technology. This was actually promulgated in 2020, and the actual implementation started in January of 2021. We have likewise, Your Honors, through our advisories, suspended the collection of FIT-all and UCEC, Your Honors. The suspension for the collection actually ran for 2 months for the FIT-all, and for UCEC, it has remained suspended because there's still the funds that have not been utilized. We have likewise suspended the bill deposit adjustments for implementation by the DUs and ECs. Your Honors, you will note that all the suspension of collections were actually done during the start of the pandemic, Your Honor. We also, the additional lifeline discount for consumers, we have issued the CHOCOS order to Meralco, and in our case, Your Honor, for the violation of advisories, that the ERC directed Meralco to provide a discount to lifeline end users with an approximate amount of 200 plus million. In its decision, Your Honors, ERC imposed a 19 million penalty on Meralco. And of course, there were issues and questions whether the penalty could be converted to refund to consumers. However, because of the law, the existing laws, we cannot convert this penalty in the form of refund. For the people allowance, that's number 5, Your Honor, the rate for 2019 is 0.226 per kilowatt hour, and for 2020, the said 2019 people rate was reduced by 0.1731 per kilowatt hour. Thus, the current pit rate is at 0.0495 per kilowatt hour. Now, for number 6 is the market transaction fees, which were actually mentioned and quite extensively discussed earlier. So, as you said, our ERC, the ERC has approved, as of now, the level of market transaction fees to be at 486 million, as against the provisional authority granted to PEMC to collect 702 million. And the difference in what was provisionally approved and the final authority given to 486 should be refunded by PEMC. However, right now there is the PEMC decided to question the decision of ERC, giving them the 486 for final authority. Now, we have also issued our decisions to make a refund to various distribution utilities. We require them to make a refund for all the pass-through charges on over-recovery in the total amount of 3,366,975,877. Out of this 3 billion plus, 2,709,395 is a refund made by Meralco to its consumers, and this has been fully refunded as of September 2020. That was last year, Your Honor. And then for the DUs other than Meralco, they were given 2 months within which to make the refund of the over collection. Now, Your Honors, for 2021, the first item there is that ERC lowered the contestable market threshold to 500 kilowatt hour. The average generation rate of the contestable customers at the end of the second quarter of 2021 is at 3.66 per kilowatt hour, which is 27% lower from the 2013 average rate of 5.02 per kilowatt hour. And the average generation rate for contestable customer decreases as the Commission lowered the threshold for determining the customer qualified to become contestable customers. In 2021, Your Honors, the Commission reduced the threshold to 500 kilowatt hour. Thus, all customers with an average peak demand of at least 500 kilowatt hours for the last 12 months are now qualified to become contestable customer. It should be noted that as of date, ERC continues to issue RES licenses despite the TRO, in as much as ERC is using the 2011 resolution on licensing as basis for the issuance of licenses. There has been no TRO that has been issued regarding this. Now, for the third item, which is the GEOP, PRC already promulgated its GEOP program rules. In other words, wala na ho kaming utang on this GEOP. And this will supplement the implementation of our COA. And while our COA's qualifying threshold is at 500 kilowatt hour, the threshold under GEOP rules is 100 kilowatt hours. Now, for item number 4, Your Honor, the secondary price cap was actually at 5 days. Now, the action of ERC is to lower the price, to lower the implementation to 3 days or 72 hours. This is a way of mitigating the, it is a mitigating measure for the prices at the West End. This is significant, Your Honor, because where the 3 days when there is sustained high prices, on the third day, then the secondary price cap will kick in. And on number 5 item, Your Honor, is the refund in OU cases or over-under cases. The ERC actually directed the distribution utilities to refund the pass-through charges and over-recovery in the amount of 2,171,233,398.40. The over or under recoveries in the pass-through charges are due to the formula being used for the charges and the time lag between the billing period being followed by generation companies, NGCP and distribution utilities as against the varying billing period of customers. So it's not something that DUs made an overcharge, but it is a result of the implementation of a formula and the difference in the billing periods. Now, for number 6, Your Honor, this is the refund in AWAT cases. The ERC directed all distribution utilities to make a refund of the total of over-recoveries in the distribution utilities, and this amounted to 13,918,887,328, Your Honor. And this 13,885,000,000 actually is only for Meralco, while Cepalco, the other DU, was made to refund by ERC the amount of 33,041,397. So these AWAT cases actually are directed or cover only 2 DUs, Meralco and Cepalco. Now, Your Honor, please. It is now our budget proposal. The previous approved budget of the ERC for the years 2020 and 2021 is 849 million pesos, and for 2021 it's 1.006 billion pesos. For the year 2022, however, the DBM reduced ERC's proposed budget from 987 million to 586 million. That's the net, Your Honor. And the 586 million, which was approved by DBM and is the NEP, is 41% lower from ERC's proposed budget for 2022. And the 586 million is 42% lower than ERC's 2021 approved budget. So, well, I don't know how we can move with just 586 million, Your Honor. Now, and because of the budget cut under the NEP, Your Honor, ERC is seeking a reconsideration of certain budget items included in our proposed 2022 budget for a total amount of 314,128, Your Honor. And the items for consideration are, number one, traveling, which will really cover the conduct of public hearings, conduct of public consultations, conduct of regulatory visits, conduct of inspection, and meter testing. So all these are part of the regulatory functions of ERC. We are likewise seeking a reconsideration of 36,000 for communication. That will cover mobile subscription and well, all those that we use every day. Number three, repairs and maintenance, repairs of machineries and equipment in the amount of 10,213,213. And this will cover the technical service equipment maintenance, the ICT machinery and equipment maintenance, the ICT repairs and maintenance, the office equipment maintenance, furniture and fixtures maintenance. And so these are all the things that we need to survive every day and to make sure that we have the good upkeep. So the bigger ones, Your Honor, are the consultancies, because as we have shown in the past, our work is dependent on the availability of funds for us to be able to get and hire consultants. So I would like to call your attention to number 11, Your Honor, the professional services in the amount of 120 million. The other professional services, which is 41,387,000, is intended to cover the salaries of the contracts of services and JOs. As we have said that our plantilla, we only have about, of the 450 manpower employees that we have, only 400 plantilla. We have a total of 456 employees working now, but of this number, we only have 295 plantilla positions, Your Honor, so that 166 or so are covered by contract of services, and the amount of 41 million plus shall cover the salaries of this COS and JOs. Now, the bigger portion of 103,599,000 of this amount that we have requested, only 41 million was approved or included in the NEP. So in other words, 79 million was disapproved, and it is this amount, the 79 million, that we are asking for a motion for reconsideration. The breakdown of the 79 million will go to the 38.